Joint Judiciary Committee's meeting for the month of October. This is our final meeting for the interim. We do have an aggressive agenda, but we have some savings throughout the agenda, particularly later in the afternoon. So I do think that we'll be able to make up for some time, hopefully today. And committee, that means we'll get you out of here at a reasonable time. We're scheduled to adjourn after 5 o'clock, but we're going to work our hardest and try our hardest to get you out of here by 5 o'clock because I know most of you will be traveling this evening. So obviously you control that as well with how many questions you ask and how long you take. And we obviously want to do good work, so we'll just do our best to balance the two. Co-Chairman Washut, do you have any opening remarks?
Thank you, Mr. Co-Chairman. Just welcome to everybody. We get to have the Dean from the University Law School talk to us today, which is going to be really a unique opportunity. Never happened in my experience in the Judiciary Committee, so looking forward to that.
Excellent.
And I think the committee is set up to work efficiently today, but still produce great products. That's our goal.
Excellent. With that, we'll go ahead and do a roll call.
Mr. Chairman, this is for the Joint Judiciary Committee for October 13th. Senator Crago? Senator Crum?
Excused.
Senator Hicks?
Here.
Senator Kolb?
Present.
Representative Brady?
Here.
Representative Bratton?
Here.
Representative Chestick?
Here.
Representative Filer?
Here.
Representative Kelly?
Here.
Representative Lean?
Here.
Representative Singh?
Excused.
Representative Webb?
Here.
Co-Chairman Washut?
Here.
You're right there in the front, Daniel, if you want to just have a seat right there.
And Chairman Olson?
Here.
We have a quorum, Mr. Chairman.
And Representative Singh just walked in, so we mark him as here. Oh, I was, but. We know you had a long commute this morning, Representative Singh. We are glad that you are here to join us in person.
Thank you, Mr. Chairman. It's a beautiful day.
Great. With that, we'll dive right into our agenda. Oh, no, I'm sorry. Let's, well, we are in our agenda, but let's go ahead and approve the minutes from the previous meeting. Okay, it's been moved and seconded to approve the minutes. Any discussion on those minutes? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, those minutes are adopted. Now let's jump into the substance of our agenda. The first item we have was referenced by Mr. Co-Chairman, who's excited for this next topic, and that is the introduction of Dean Hill from the University of Wyoming College of Law. Welcome, Dean.
Thank you. It's great to be here. Members of the Joint Judiciary Committee, I appreciate you having me here today. I'm Julie Hill, and as has been said, I'm the Dean of the University of Wyoming College of Law. I joined the College of Law just over a year ago, and it's my pleasure today to share with you an update about some of the wonderful things that have happened at the College of Law in the last year. As you're probably aware, just over a year ago, we moved into the new Alan K. Simpson Center for Clinical and Experiential Learning. This 20,000 square foot addition to the College of Law provides space for our students to gain hands-on legal experience while representing clients of limited means. The impact of our clinics is felt throughout the state. Last year, our clinic students represented 58 clients in 21 of Wyoming's 23 counties. On behalf of the College of Law, I want you to know how profoundly grateful we are to the Wyoming Legislature for making the Simpson Center a reality at the University of Wyoming. In addition to completing the building, the College of Law has had several important successes in the last year. I'm not going to bore you with all of them, but I want to highlight just a few. This fall, we enrolled the academically strongest class in the College of Law's history. The median score on the law school admissions test was 156. That's up 1 point from the year before. And the median undergrad GPA was 3.53. That's up from 3.46 the year before. As part of that class, we admitted our first ever student, Ryan Fogg, to an accelerated 3+3 program. So this is a program that we offer in partnership with the School of Energy Resources, and the program allows students to earn both their undergraduate degree and their law degree in a total of 6 years instead of the usual 7. Well, in the last year, we also hired 2 new faculty members. First, we hired Grant Smith, who graduated from the College of Law in 2014. He was hired as an assistant professor of law and the director of our Defender Aid Clinic. He'd previously worked as a federal public defender in Wyoming and Colorado. Our second hire was Mario Rampula, who graduated from the College of Law in 2004. He was hired as an assistant professor of practice and as director of our estate planning and probate clinic. Mario is the founder of that clinic and has practiced estate planning law in Laramie since he graduated from law school several years ago. And then finally, I'm pleased to report that the pass rate for first-time takers of the Wyoming bar exam this July was 82%, which is up from 74% the year before. As you're probably aware, the mission of the College of Law is to provide a high-quality legal education to our students. This year, others have noticed some of the great work that we're doing. First of all, we have been recognized for our world-class legal writing program. U.S. News and World Report ranked the College of Law as the 17th best legal writing program in the country. The program is led by Professor Michael Smith, who is a nationally recognized expert in legal writing. Your colleague, Representative Chestick, also teaches in the program, so please be sure to congratulate him and thank him for all the work that he does at the College of Law. Our Law Review has also received special recognition. The Wyoming Law Review is a student-edited academic journal. Nearly every law school has a law review. Many law schools have more than one law review or academic publication. These are the primary publishers of academic legal writing. Courts and judges often look to law review articles when making decisions, particularly in emerging or thorny areas of the law. Earlier this year, Adam Feldman, an expert in legal data and analytics, prepared rankings of law reviews measured by citations in court cases between 2019 and 2023. Of all of the law reviews in the country, the Wyoming Law Review sits in 8th place. For context, that puts us just behind Harvard and Yale and just ahead of Stanford. Since I have mentioned the Wyoming Law Review, I wanted to also mention that they'll be hosting a symposium this Saturday at the Gateway Center over in Laramie. It's going to address the legal issues in C.J. Box books. Mr. Box is attending the event and providing a keynote speech, and we're very excited. We're going to bring in academics and practitioners from around the country. We will also have a falconer, so if you have a little extra time on Saturday and want to come to Laramie, we'd of course love to have you at that event. Finally, I'm especially proud to report that the faculty at the College of Law was recognized because they are exceptionally accessible to students. Every year, the Princeton Review conducts a survey of law students nationwide. One of the things surveyed is how accessible the faculty is to law students. This year, the University of Wyoming College of Law was tied for 10th nationally. While we are proud of these and other successes, I want you to know that we are not satisfied. We are always looking for ways to improve our student experience and to expand the impact that we have in Wyoming and beyond. We're currently searching for 4 new faculty members. Not sure if we will get them all hired this year, but I expect we'll have some good new additions to the faculty by this time next year. We're also working to provide more academic support services for our students. We hope this will make it easier for our students to pass the bar and find meaningful employment in our area. And we're working to develop better relationships between the College of Law and the legal community in Wyoming, who are some of our strongest supporters. I want again to emphasize how much the College of Law appreciates your support and the support of the Wyoming legislature. I want each of you to feel at home at the College of Law, at least as much as anyone can feel at home at a law school. I promise if you come, we won't call on you. I hope that if you're in Laramie, you'll stop by and see the beautiful new building. I hope that if you need access to legal resources in our library, you'll reach out. We have some wonderful librarians. I hope that if our students can help you with a project, you will let us know. And I hope that if you need a place to meet, you consider the College of Law. Above all, I want the College of Law to train excellent lawyers and to be a resource for the state of Wyoming. Please let me know how we can help, and go Pokes. I'm happy to answer any questions you have.
Questions for Dean Hill? Yes, Co-Chairman Washer.
Thank you, Mr. Chairman. Dean, it's a pleasure to have you with us today. Quick questions on 2 points. One is rural attorneys. A couple of years ago, we had a bill suggested to try and help locate more lawyers in small towns in Wyoming. Is the law school at all involved with that initiative on an ongoing effort, or is it passed? And secondly, you have 4 faculty positions open. Are your present salaries adequate to attract the best talent that you can get for those positions?
Dean Hill?
So on the first question, we have and have long had a rural law center. It's headed by our senior associate dean, Alan Romero, who's been at the law school for at least 2 decades now. So it does a number of things. One of them is he works in partnership with the Wyoming State Bar to host several conferences a year, typically at the law school. And what we hope that those conferences do is that they act as a resource for rural attorneys practicing throughout our region to come and learn. Because I think one of the barriers to attorneys practicing in small towns is that they're worried about mentorship and about developing their skills as a lawyer. If they come practice in Cheyenne, there are attorneys around them that they can reach out to, but it's a little harder if you're the only attorney for 100 miles. So that's one of the things that we're working on. Another of the things that we have started to do is, as part of our legal liftoff program during spring break, we work to place law students in job shadowing placements. And so they go to a rural prosecutor's office or a rural judge's office or a rural legal practice and spend part of spring break there making connections and understanding the legal needs in that community. And through that process, we've been able to show some students who were previously not considering those opportunities that it would really be quite a good fit for them. And some of those local communities, Carbon County is one example, have provided some money for that initiative so that our students can have a place to stay while they're there in spring break, so that we can send students who don't have family in the region. And you mentioned this other initiative. Some other rural states have had success in providing startup funds or seed money for attorneys who are going to go start a practice in a rural area. I think the legislature considered that before I came and decided it was not something that they wanted to fund. But we have had conversations with the state bar and with donors about how we might be able to create a program that provides some startup funding, but we're not all the way to getting that done yet. And so I think that's something that it's fair to say it would be helpful in getting people placed there, but it's also not the only thing that we're working on when it comes to making sure that we have representation in rural parts of Wyoming. And then the other question was about our 4 faculty hires. So the faculty hires we're currently working on are a new director for our civil legal services clinic, someone to teach environmental and administrative law, someone to teach constitutional law, and someone to teach torts. Again, we're hopeful we'll be able to do it. We were able to hire 2 faculty members last year and 1 faculty member the year before the salaries we're currently offering. our salaries are not the most competitive for faculty of anyone, but we like to think that the University of Wyoming College of Law is a particularly attractive place, especially for somebody, for example, who wants to practice environmental and natural resources law. We've also had good success recruiting people who just really love Wyoming. And I suppose I'm a good example of that. Some people are willing to take a bit of a pay cut to live in a place they really love, and that's not the worst thing to have on the faculty at the University of Wyoming. So we're going to do our best to recruit with the resources that we have and do our best over time to make sure that we have the resources to have a first-rate law school.
Any other questions for Dean Hill? Representative Lean?
Thank you, Mr. Chairman. Thank you for coming today, Ms. Hill. You talk about a wage gap. Could you give me maybe a percentage or an estimate by how much behind we are in the wages?
So we're currently in the process of doing a faculty salary study, so I don't want to get ahead of that. I think I don't mean to be evasive on that. It's just I want to, I'm a former banker, so I like to have my numbers straight before I start handing them out in public meetings, but that's one of the things that we're studying. I think that it's been a while since we've had a raised pool, and then that combined with inflation leads me to think we're a little low, and that's why we're doing the study. But I don't want to run around saying that we're severely underpaid until I have the numbers to back that up, and maybe I won't have them at all.
Representative Chesick?
Thank you, Mr. Chairman. Not a question so much as a thank you for your leadership and all the great things that are going on in the school. I just wanted to let people know that I have the great pleasure this semester of having a former staff member of LSO in my class. So we serve the whole community, and I'm glad to be here. Thank you.
And we appreciate the fact that you will continue to work at the law school, even though I think this is not what a lot of people do in retirement.
Yes. Oh, Senator Hicks, go ahead.
Yeah, thank you, Mr. Chairman. Dean, a real quick question, and it's a spinoff of what Co-Chairman Washut was. But how do you feel in your tenure at the law school and the direction that the law school can fulfill the mission of the land-grant university? So how does that look in the law school? What does the law school specifically emphasize to fulfill the land-grant university mission of the University of Wyoming?
So I think that there are several things. I mean, I guess it's how broadly you want to define the land grant part of it. But as I mentioned, we're working on our Rural Law Center initiatives. We also have a robust environmental, natural resources, public lands related curriculum. We're also just focused on making sure that students have the skills to go out and practice throughout the state. So one of our fastest growing and most popular clinics is the one that is started by Mario Rampulitz, an estate planning clinic. And one of the types of law that is in high demand in rural areas is actually estate planning. He and his students made a presentation at the Wyoming State Bar. It was really impressive, an hour-long presentation from law students providing advice to attorneys on how to plan for estate plans for closely held family agricultural businesses. And so I think that first and foremost, the College of Law is looking to provide people a general legal education so that they can go and do lots of different things. But we are very much aware that involves serving the people of the state in all parts of the state, including the more rural areas of the state. And so we do that through our curriculum and through the opportunities that we give the students to make sure that they're able to go and practice in these areas. And I might just say too, this is part of the reason that I came to the University of Wyoming. I myself am from a town of about 1,500 people without a stoplight and without any attorneys. When I went to law school, I did not know any attorneys. And lots of our students are like that. This year at orientation, I asked the students who didn't have any attorneys in their family to raise their hand. And about 75% of the first year class raised their hand. And so, I think that it's kind of a funny joke to say that lawyers don't help the world, but I know firsthand what it's like to live in a place that doesn't have any attorneys, and it's not ideal. It means that people have trouble creating new businesses. It means that people have estate planning problems. It means that people who want to get divorced are still married. It means that people who have problems with criminal law don't get those addressed. And I think that's something that matters a lot to me. And it matters a lot to me that the University of Wyoming prepares students to handle those problems.
Senator Hicks, follow-up?
Yeah, just to follow up. So I appreciate that answer. I think you kind of hit the nail on the head, but it seems to me like, and you've mentioned this, given that response, how do you see using clinics to further that mission?
So we have several different clinics, and the purpose of the clinics is to make sure that students have some hands-on legal training before they go out into the world. So we have a defender aid clinic that represents people largely in post-conviction and sentencing issues. We have a prosecution assistance clinic that works with prosecutors throughout the state. We have a civil legal clinic that we sometimes call the kitchen sink clinic because it takes all sorts of different kinds of civil matters. We have a family law clinic that does family law. We have an estate planning and probate clinic. We have a business law practicum that helps people and nonprofits set up businesses. And we have a human rights center that works with nonprofits nationwide on human rights issues. But the point behind all of these clinics is so that when students get out of law school, they haven't just been sitting in the classroom reading books, that they've been representing real clients. So that we have the client come in and they tell the students what their legal problem is. And a lot of times clients aren't that good at diagnosing what their problem is. It's kind of like you go to a doctor to figure out what's wrong with you, not because you figured it all out by WebMD. It's kind of the same thing with law. Students learn how to talk with the client, figure out what the problem is. They learn kind of the difference between the law as it's written in the books and the law as it's applied. And so what we hope is that students get this experience and then they can go out and immediately put that to work. And so while we hope that everybody goes out and has mentors straight away, we hope that also if they go to a place where there aren't readily available mentors, they have some level of training to fall back on. And then the other part of our clinics that is very useful to the state is, like I mentioned, I mean, that's 58 clients that we represented last year who didn't have the money to pay for a lawyer in Wyoming. Those are 58 people who wouldn't have had access to justice, wouldn't have access to legal services unless our clinic represented them. And, we represent people throughout the state. If we look at us over 3 years, we've been in every county in Wyoming. And so we think that it's not just about training lawyers for the future, it's also that the work that these do is really an important part of providing legal services throughout Wyoming.
All right, thank you, Dean Hill. Any other questions before we let the dean go? All right, we do appreciate you coming. Like Co-Chairman Washut said, I think in all my time on this committee, which I've been involved in some way or another for almost a decade, this is the first time the dean of the law school has presented to us. So we appreciate that, and hopefully it becomes a long-standing relationship in the future.
Indeed. Well, thank you for having me. And of course, you don't have to wait for a hearing. If you need something from me, you'll just pick up the phone and call.
Great, thank you. Public comment, is there any public comment on this topic? Any online? No public comment. Okay, we'll just roll right into the next topic, which is the Wyoming Department of Family Services confidentiality statutes. We have a bill for consideration. It's 26 LSO 0075 version 6. You are all familiar with this bill. Was there anything different in this bill from the last time we saw it?
Yes, Mr. Chairman, there were two changes, and so on page 2, lines 16 and 17, the committee in August amended that language to change that third purpose for which the confidential data may be shared in the Department of Family Services, studying the effectiveness of the programs. And that language changed from participation in bona fide research to participation in data analysis and program evaluation. And so there and at one other place in the bill draft on the top of page 5, that was changed. Otherwise, the bill draft is identical to August.
Any questions for Mr. Fuller on the changes to this bill draft? If not, we'll just roll right into Director Schmidt. Welcome, Director.
Thank you, Mr. Chairman, Mr. Co-Chairman, members of the committee. My name is Corinne Schmidt. I'm the Director of the Wyoming Department of Family Services. And with me today, I have Daniel Marks, who's our Senior Policy Advisor. Thank you for the changes that were made. They resonate with us. They are workable for us, and I do think it makes for a stronger bill. But in addition to that, after the comments through testimony and through your conversation in the August meeting, we did a little bit of soul searching and really started to consider what the language of this bill was presenting, specifically around the purposes of referrals. And there were a lot of questions about exactly how it is we would be using this piece of legislation in order to better connect families. And as we kind of walked through looking for ways that we could better explain this, the origination of this particular provision, the referral of services, is because of a very strict interpretation of one particular statute. And we had brought it into this bill mostly because we wanted to be able to have this conversation in a kind of in a more general way. But if it serves the committee a little bit better, we would be fine with striking any provision around the referrals, and then through the interim come back with that one piece of statute that causes us problems and have a different discussion around that. If you're fine with referrals sticking in there, certainly that works for us. I mean, it makes it easier for us to do a lot of our work, but certainly I know that that was a big point of conversation. And we just thought of another way we could come back around to it and do a little bit more education and get a little bit more specific. So with that, Mr. Chairman, we don't have any further comments.
Questions for the director? Yes, Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. Could you please remind me the original intent of bringing this forward as an interim topic?
Sure, Mr. Chairman, Representative Lean, there were 3 reasons why we were bringing this bill forward, and this has come up a couple of times. The first one was around the referral of services, which is what I just hit, and that was really trying to connect families with community resources within the context of our current statute, which says that we really can't do that. The second part of it is for services, and that's the provision of services. And that's more connecting the data in between agencies and even within our own agency. So for example, the Juvenile Justice Information System was a system that this committee had asked us to implement a handful of years ago. We've implemented it and it's working, but we cannot connect it with our other system that has juvenile justice information called WyoSafe. So we have a juvenile justice information system that captures some juvenile justice data. We have our WyoSafe, which collects our case management for kids that are involved through juvenile court, but we cannot connect the two. And then the third one is the changes that were made, and that's research and evaluation over time. How are our programs doing? Are people doing better? The example in the legislation is around the state longitudinal education data set. Are kids that are involved in our system getting the education that they need? How are the outcomes for those educational interventions? So in general, those were the three specific reasons.
Follow-up?
Yes, follow-up, Representative Lane.
Thank you, Mr. Chairman. I heard you say earlier that you might be willing to strike the referral information program. So I guess my question would be, with the intent of legislation being the three pieces and the first piece being the referral services, which piece is the most important of this legislation?
Director.
Mr. Chairman, Representative Lane, I would say the provision of services and the evaluation are the two components.
Co-Chairman Washington.
Thank you, Mr. Chairman. Director, appreciate you being here this morning. Could you maybe give some examples to the committee how with this type of data sharing, information sharing, your department might be able to give this committee better information with which to make policy decisions? That was kind of the undergird of moving all of this to DFS in the first place.
Director.
Mr. Chairman, Mr. Co-Chairman, so hearkening back a while on the juvenile justice conversation, I think it started in 2019, possibly 2020, where there was a lot of conversation about juvenile delinquency and juvenile justice specifically. And in Wyoming, we do not have a juvenile justice system per se. There's bits and pieces of the juvenile justice system that show up in different jurisdictions. Municipal court has some authority over juvenile justice. Circuit court has authority over juvenile justice. And district court, which is where Title 14 is, and that's mostly where DFS lives, has a jurisdiction over juvenile justice. Because of that, there's no way to look at any type of consistency between a juvenile that shows up in municipal court that may work their way to circuit court that then ends up in juvenile court. So as there was conversation about reform to the juvenile justice system, it became very apparent to this committee and to all of us that work in this space that there's really no way to know or understand how a juvenile progresses or where those opportunities for intervention may be. In addition, we have some statistics that show we have a high out-of-home placement confinement rate, which means that a lot of our youth are going at a higher proportion into some sort of detention or confinement order, a court-ordered placement, higher than a lot of the other states. It's impossible for us to even really talk about the why because of the disconnects between the systems. So what this committee had suggested was creating a juvenile justice information system. And that collects information that was once gathered by DCI. So originally, the Division of Criminal Investigation through the Attorney General's office was tasked with collecting information from the courts, the circuit court. That information was somewhat being gathered, but it was sitting in a place where it couldn't be analyzed, it was hard to access, and certainly you couldn't draw any conclusions about it. So this committee then provided us with funding and switched those statutes over into DFS, into Title 14. We created this new juvenile justice information system. So we are getting that data. However, we cannot connect it to our own internal data to really give us an understanding of eventually which of those kids are going into a long-term placement or detention or some sort of, or boys' school or girls' school would be another example. So this legislation would certainly provide us with the opportunity to start to combine that data and to analyze it. From a practitioner standpoint, I think what's really important for us is to understand the role of diversion in all of this. It's hard for us to know about diversion, when diversion is effective and when it isn't, because the two systems are separate. Most diversion is run through circuit court. It's not run through juvenile court or a district court judge. So we don't know how many youth have maybe experienced diversion that ended up in juvenile court. Or we don't know how many kids maybe were diverted and the success of that particular system, because we can't necessarily know they didn't come to juvenile court.
Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Morning, Director.
Good morning.
Guess, you know, I certainly believe in the reason for this draft bill, but I do have questions about your group of folks, your agency, and has there, you know, basically the question is this: have you had any breaches in data, any inappropriate letting go of information that goes against your policies? I'm just going to assume they're good policies. That because a lot of this conversation is about, well, what if this data gets out to the wrong folks? What happens if it's dispersed improperly, and just what happens in that scenario? So could you help me out to understand the past? Has there been any issues? That's really the question. Has there been any issues in past years that you're aware of that have led to situations where information was given to the wrong entity, persons, whomever it may be? Could you help me with that? Thank you, Director.
Director Schmidt.
Mr. Chairman, Senator Kolb, in terms of our data systems, we've not had a breach within the Department of Family Services. Our data systems live on something called Salesforce, which is a platform that comes with a lot of data integrity, security, cybersecurity, which is one of the reasons why our systems live on that. So it receives the protections of a lot of the most up-to-date cyber awareness type technology. That's in terms of our data systems. Of course, we have humans working in our system, and there has been, in my recollection, one incident of a personnel action where somebody gave information inappropriately, but that was specific to one case. That wasn't a data system issue.
Follow-up, Senator Kolb.
Yeah, let's follow up. Director, I was specifically talking about people, not hardware. And thank you for, how long ago was that? Was that one instance that you're aware of? And
Oh, Mr. Chairman, long enough that I can't remember. I would say maybe early 2020s.
Thank you. Any other questions for Director Schmidt? Yes, Representative Lynn, go ahead.
Thank you, Mr. Chairman. Could you please remind me how long the data is intended to be stored for?
Mr. Chairman, Representative Lean, currently our Child Protective Services data is held on to for almost 100 years. We are going through all of that and looking at the retention issues and the retention schedule and revising those. We don't need that data for that long. That's a legacy decision that was made.
And we don't sort that out in this bill. I suppose we could, but you will address it in your rules and regs.
Yes, Mr. Chairman, that's where it sits right now.
Great. Any additional questions for the director? All right. Thank you, Director. Public comment. Or Ms. Marks, did you have anything? I'm sorry, I didn't ask.
Mr. Chairman, no, I don't. Thank you.
Okay, thank you for being here today. Now we'll move into public comment.
Good morning, Chairman.
Good morning.
Members of the committee. My name is Patricia McCoy. I'm a resident of Laramie County, and I'm here speaking today to express my serious concerns regarding this proposed legislation. I believe that the current draft of this bill poses significant risk to individual privacy and may enable harmful practices that undermine the welfare and rights of Wyoming residents. I appreciate the committee's intent to enhance oversight and accountability within the Department of Family Services. It is much needed. But this bill appears to expand the circumstances under which confidential information held by the DFS may be accessed, reviewed, or disclosed. This includes sensitive personal data pertaining to children, families, and vulnerable individuals engaged with the department. The broad language regarding who may access these records and for what purposes raises several red flags to me. Insufficient safeguards are in place right now. This bill does not clearly define or limit who is authorized to review confidential records, nor does it specify rigorous criteria for such access. The lack of detail could result in unauthorized individuals or entities obtaining sensitive information without adequate oversight. There's risk of re-identification. Even if information is technically de-identified, the context and details in DFS records can often be used to re-identify individuals, especially in Wyoming's smaller communities. This could lead to breaches of privacy for children and families at their most vulnerable moments. There is lack of consent in this bill. It does not provide mechanisms for affected individuals or families to consent to or even be notified about the release or review of their confidential records. This undermines the principle of informed consent that is fundamental of privacy rights. Beyond the privacy concerns, the structure of this bill raises questions about its underlying intent and the potential for harmful outcomes. This could have a chilling effect on help seeking. If families and individuals believe their confidential information may be shared widely or without their knowledge, they may be discouraged from seeking help from DFS, and this could result in underreporting of abuse, neglect, or other crises. Stigmatization and retaliation is also possible through this bill. The possibility of sensitive case details being disclosed, even inadvertently, increase the risks of stigmatization in tight-knit communities. Families and children could face social ostracism and retaliation as a result, especially in our small rural communities. I mean, even in Cheyenne, most people know everybody in the town, everywhere you go. Undermining trust. The DFS operates most effectively when it has the trust of the communities it serves. Weakening confidentiality protections damages this trust, making it harder for the department to fulfill its mission or supporting and protecting families. To address these serious concerns, I would urge this committee to clearly define and narrowly limit the circumstances under which confidential records may be reviewed and disclosed. Establish robust safeguards, including oversight mechanisms and penalties for unauthorized access or disclosure. Require informed consent from individuals or families whenever possible before their information is shared, and conduct a comprehensive privacy impact assessment before enacting any changes to DFS confidentiality practices. While oversight and transparency are very important, they must not come at the expense of individual privacy or the well-being of children and families. I respectfully request that the committee reconsider the provisions to ensure that privacy rights are protected and that the Department of Family Services can continue to serve the people of Wyoming effectively and ethically. Thank you.
Questions for Ms. McCoy? All right, we appreciate you being here and thank you for your testimony. Other public comment in the room? Any public comment online? All right, with that, we will close public comment. Back to the committee. Committee, what is your pleasure? It's been moved by Co-Chairman Washut, seconded by Representative Chestik. Are there any amendments to this bill? Senator Kolb?
Yeah, thank you, Mr. Chairman. Yeah, page 3, line 6, the fine amount from $500 to $1,000.
Did you say 1,000?
Yes, Mr. Chairman.
Okay. There is a motion. Is there a second? Do I have a second on that motion? It's been seconded by Representative Lean. Discussion on this motion?
And then, Mr. Chairman, I assume a conforming change to the bill title as well.
Oh, good catch. Glad you're here. I think Senator Cole said that.
Mr. Chairman, yes, I did.
Okay. Perfect. Any discussion on this amendment? Representative Filer.
Thanks, Mr. Chairman. I was just wondering with the misdemeanor and conviction of the $500, is $1,000, is that more in line with most misdemeanor or $750? I just think there's a lot of different misdemeanors and we're floating out there. There's a whole bunch of different fines.
I would ask Mr. Fuller, but my gut is telling me that actually 500 would be itself inconsistent, that it's usually 750 to 1,000 is what they usually say. I think, Mr. Fuller, is that accurate?
Mr. Chairman, the standard is generally 6 months, $750.
Yeah, so this one is a little unusual. Not the amendment, but how it is already written. Yes, Senator Cole?
Yeah, Mr. Chairman, just to add more color to this, the reason is that, I mean, we've heard that there's been one breach of, inappropriate behavior or whatever that had happened. I think there's a lot of people that are uncomfortable with this whole topic, and I thought, well, if we increase the fine up to $1,000, that it would maybe sit better with people to say there is more of a repercussion for violating this statute than at 500. Yeah, typically I think it's 750 is what you see for a misdemeanor to answer your inquiry that the attorneys have already answered, because I'm not an attorney, but I've seen that number. So that's the reason why I proposed the $1,000 as an increase. It hasn't happened very often, but I don't want it to happen at all. And that's the reason for the amendment. Thank you.
Any other discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed? That amendment has been adopted. Are there other amendments to this bill? Any discussion on this bill? Yes, Co-Chairman Washington.
Thank you, Mr. Chairman. Just to reassure folks, the language on line 15 on page 2 emphasizes that federal restrictions still are in place. All right, so this is just dealing with some of the data sharing that has impeded this committee's ability to make good policy choices. The federal restrictions in terms of individual privacy still exist. We're not changing any of that. We can't change any of that. What we're doing here is giving the opportunity for the department to share this information in a way, especially the data analysis aspect. There's just so many gaps in our understanding about how different interventions work or don't work. Young people come into the program, some of them do terrific and we never hear of them again. Others progress into the adult correction system and they're just bound. And so I think the sooner we are able to get good information that helps us understand what interventions work under what circumstances and what interventions are a waste of money and a waste of effort, the better it will be for this committee going forward to make good policy decisions in this arena. So I strongly support the bill.
Any other comments on this bill? Yes, Representative Webb.
Thank you, Mr. Chairman. And thank you, Mr. Co-Chairman. I understand. I think there is a lot of things that need to be looked at in this bill to secure data, to secure things that can help our youth, can help families. And that's the reason that I will be a no in this, is I don't know that we have. I think we need to look at those things before we impose a bill such as this one. I think that will do it for right now, but I will be a no on this bill.
Thank you, Representative Webb. Representative Lean.
Thank you, Mr. Chairman. I just want to say that I really heard what the Director of Department of Family Services said, and that she's piecemealing together the juvenile justice system information because we don't have adequate authority across the board. My recommendation would be that the legislature take some time to really put together a good dive into the juvenile justice system and all of its programs together to be able to make one clear, concise bill that fixes a plethora of problems instead of continuing to piecemeal this together. So for that reason, I'll be a no today.
Any other discussion? All right, let's go ahead and vote.
Mr. Chairman, this is a roll call vote for 26 LSO 75, Department of Family Services Review and Confidentiality as amended. Senator Crago? Senator Crum?
Excused?
Senator Hicks?
Aye.
Senator Kolb?
Aye.
Representative Brady?
No.
Representative Bratton?
No.
Representative Chustik?
Aye.
Representative Filer?
Aye.
Representative Kelly?
No.
Representative Lean?
No.
Representative Singh?
No.
Representative Webb?
No.
Co-Chairman Washit?
Aye.
Chairman Olson?
Aye.
Yep, Mr. Chairman, that motion fails by a vote of the House.
Thank you. All right, the next topic for our discussion is the obscenity laws discussion, and I want to preface this with just a reminder to the public that we did take public comment at our last meeting. It was very extensive, and we made the determination that we would carry this bill over to today's meeting without public comment, so we did close public comment on it. And today, we've really reserved our time to potentially work this bill, if that's the pleasure of the committee, that is. So just throwing that out there so that our public is well aware that we will not be taking any comment on this bill today. Yes, Representative Webb?
Because there's been some changes made to this bill, I think that it might be appropriate if we take some limited public comment. We don't need to spend all day, but I think that I'd like to make a motion that we do that.
Yeah, that's not a bad idea. I don't know that you need a motion, but we could take public comment specific to, after, if we work the bill and we have some amendments to it, then we could take public comment specific to the amendments. I would be okay with that. Are you okay with that, Chairman Washut? We'll just keep it tight.
You know, we've been announcing for weeks that there wouldn't be any public comment. So I'm concerned that folks who might have wanted to participate
Didn't show
aren't
up.
here and have not logged in because we've been announcing that this would just be a work session for us to work the bill. Just keep in mind that, you know, if the bill does advance into the session, the bill will have opportunity for public comment. Once it's engrossed with any changes we make in it today, if it goes forward, the public will have an opportunity to weigh in during the session.
Senator Kolb?
Yeah, thank you, Mr. Chairman. I feel the same way as Co-Chair Washut feels. I think we wouldn't give the other side the opportunity if they wanted to show up to, to speak, because I didn't think they could. So I am really concerned about that. And for me, I'd rather not take public comment because we haven't given that equal opportunity or published the equal opportunity to the public to do that. Thank you, Mr. Chairman.
Okay, I can appreciate both sides of it. I think that, Senator Hicks, go ahead.
Yeah, Mr. Chairman, I'll be brief, but I would agree with Chairman Washut that if this moves forward, there's going to be a number of committee meetings. There'll be ample opportunity for the public to weigh in on numerous occasions
during the session if this bill moves forward. So I would resist any public comment.
Okay, well, with that, go ahead, Representative Singh.
Thank you, Mr. Chairman. Just my thoughts. You know, a lot of the times when I'm working on bills, I think that the public has thought about it a little bit harder than myself, and I value what the public has to say, and so I would advocate for just giving another opportunity for the public today.
Okay, Representative Brady?
Thank you. Since there are so many amendments, I'd just like to agree that it's always better to err on the side of more public comment. Thank you.
Any others want to try to persuade me? All right, well, I appreciate everybody weighing in. I think it is, this is a very important topic for the Judiciary Committee, and it's a very important topic for the community. I know that because my email, my phone, and my texts have been blowing up like crazy, like I'm sure all of yours have. Community members contacting me as well. So there's no doubt that this is a really important issue, but I'm going to go ahead and stick with our original decision that we did take public comment. So public comment will remain closed. And if there is public comment, there is no doubt in my mind that those in the public know how to find our emails. So I'm sure they can get us the comments that they wish for us to hear. So with that, we'll go ahead and move into the topic. Mr. Fuller, we have Bill Draft 26 LSO 0080 version 5.
Yep.
And 1 second, Representative Chestik. And we didn't make any changes to the bill, so the bill is the same. Everybody has already seen this bill, so we won't make you walk through an introduction of it. Rather, I think if there are any questions about the bill as it is currently drafted, we can ask those of LSO. And if there are not, then we'll move into our working session. Any questions about how this bill is drafted or any provisions of the bill that you want to ask Mr. Fuller? Okay, Representative Chestik.
Thank you, Mr. Chairman. Given the number of amendments that we have and the sense that maybe more public discussion would be useful, this bill seems to me like it's not ready for prime time. And rather than spend what could be several hours now going through a lot of these amendments, I would like to move to table the bill at this point.
Mr. Fuller, does a motion to table require a second? And is it debatable?
Yeah, Mr. Chairman, I think by the strict rules of the committee, it would not, it would be in your prerogative if it needs a second or not. The rules do not expressly say that. I mean, typically motions do require seconds.
And what is the vote on a motion to table?
This would be a majority of the committee because it's not a motion to sponsor legislation.
Okay, I won't require a second because I think that's consistent with the rules that we've operated under in the past. But there is a motion to table, and we will, did you say we could have discussion on them? Or is it not debatable?
Generally not, no.
Okay, this is not debatable, so we'll go straight to a vote, and that'll be a voice vote. All those in favor signify by saying aye. Aye. All those opposed?
No.
Okay, that motion does fail. With that, let's move into the discussion of this legislation as it pertains to amendments. And give me just a second here to get this pulled up.
And Mr. Chairman,
Yes.
if the intent is to begin with amendments, a motion to sponsor the bill would be in order first.
All
Mr.
right.
Chairman, I move the bill.
It's been moved. Is there a second? It's been seconded. So the motion is properly on the table. Thank you for that, Mr. Fuller. With that, we will take any amendments to this bill. Let's do it page by page. Page 2, are there any amendments to page 2? You want to go to page 1, the title?
Just a quick question on the bill title where references explicit materials by minors on line 4. Is minors the right terminology to use there?
Mr. Fuller?
So Mr. Chairman, I think the bill is drafted to concern the children's section of a library defined to mean those younger than age 18. So I think minors is appropriate.
Because we call them children in the bill, right? Those under 18 are called children by definitions in the bill.
Children's section?
So Mr. Chairman, Chairman Washit, that's just a term, candidly, just a definitional term. This is page 2, line 13, where we just use the term children's section. That's just a definition, a shorthand. The specific language refers, this is on line 15 on my copy, toward persons younger than age 18. So I don't think, other than referring to it as a children's section, I'm not sure the bill necessarily refers to children anywhere else.
Okay. Any amendments? We'll probably circle back to the bill title depending on what amendments are made. So I'm going to start us on page 2. Any amendments to page 2? Yes, Representative Cheswick.
Thank you. I have several amendments on page 2. Let me find them. Actually, one of the ones that was circulated earlier was my amendment number 7, which is on page 2, line 14 and 15. And it's to strike the words "or that provides materials aimed toward." And the reason for striking,
Well, hold on. Let's take it one step at a time. So make the motion, and then if there's a second, then we can discuss it.
Okay, I move that we, on line 2, page 14, page 2, line 14 and 15, delete the language "or that provides materials aimed towards."
Okay, there is a motion. Is there a second? It's been seconded by Representative Lean. Now, Representative Cheswick, you may discuss it.
Thank you. The reason for this change is to prevent the entire library from becoming a children's section. So the way the bill is worded, children's section is defined to be any portion of the library devoted primarily to or that provides materials aimed towards. The "or that provides materials aimed towards" kind of turns the entire library into a children's section, because whether materials are aimed towards persons younger than 18 is not a determination made by the library. It's a determination made by the author of the book, and then there's some other agency that categorizes books as aimed for certain audiences, and those determinations are not made by the library. So if the bill requires public libraries to move materials out of the children's section into the adult section, the materials are still aimed towards children. And therefore, now that they're housed in the adult section of the library becomes a children's section. So I'm trying to limit this so that only the separately identified children's section is what's covered by this, and moving materials from that section into the adult section does not make the rest of the whole library an adult section.
Representative Filer?
Yeah, thanks, Mr. Chairman. And I think on that amendment, I think the key point of that is materials aimed. I think that's the key words, because all materials are defined to aim towards something, right? So I think that's those key words right there, materials aimed towards. So even if they're in a different section, put that, maybe that writer or that author, it's aimed towards a certain population. So under that, when we look at that definition there, I think that Representative Cheswick's onto something on that, but I am not an attorney, so I'll refer to you guys.
Mr. Chairman.
Yes, Representative Singh.
Thank you, Mr. Chairman. Just some thoughts. There were 2 methods of like age categorization just mentioned by Representative Cheswick. One was that of the author's intention, and then the other was that mentioned by some sort of marketplace that determined the restrictions or the classifications based on their own metrics. Many of the books that we're talking about here today would, by the author's definition, not be considered sexually explicit, but by the marketplace's definition would absolutely be considered sexually explicit and be categorized as 18 plus. And so just as that pertains to the amendment itself, that's just something that came to mind as we're talking about it.
Senator Colton?
Thank you, Mr. Chairman. I'm concerned about this amendment. I think that, that we had a topic of discussion where, what do we do with a librarian that doesn't want to segregate areas for a children's section? And this, in fact, is kind of a workaround on that in a way to me. I think the language starts off as children's section means any portion of a library. So I think that's, when you start taking that thought forward, it seems to me like I don't see the problem here. I think it's a workaround trying to say that, well, then the library itself, if we say that that portion of the library, we're going to exempt it. I guess I'm a little confused about how this really would interplay into making a library have a section for children. That's really my question. Thank you.
Representative Craigo?
Thank you, Mr. Chairman. So,
Senator Craigo?
yeah, it doesn't matter. So just to, I think maybe provide a little bit of clarity, because I agree with the proposed amendment. What the representative is saying is, so we assume there's a book that's aimed at children, and let's say it's aimed at adolescents 15 to 17 or whatever, right? And it's in the children's section, and it qualifies as sexually explicit, obscene under the proposed statute. The library then moves that book to the adult section because they aren't required to take it out of the collection, but they have to take it out of that portion of the library. So they take it out of the children's section. Based on this language, they've just made the adult section of the library a children's section, because that particular material is aimed towards people younger than 18. And so there wouldn't be a quote-unquote children's section and an adult section. It would all be the children's section. And so that's what the representative's trying to get at with the amendment, and I think it's a good one.
Representative Brady or Lean? Representative Lean?
Thank you, Mr. Chairman. To follow up on Senator Craigo's, this is a great example. This book here is The Lawn Boy. It is gauged towards people 10 years and older, but if it's got clearly sexually explicit material in it, any of you are welcome to read it. It's currently tagged. But if we did move it to the adult section, does it then become the child section? So my question is, for LSO, I guess, is that the case where we have this book that says 10 plus, clearly has sexually explicit materials in more than one location? Do we then make the adult section a child section with the current verbiage versus Cheswick's amendment?
Mr. Fuller?
Yeah, Mr. Chairman, Representative Lean, the way I would read it means any portion of a library, and I'll omit, I think there's two pieces of it that have been identified. Any portion of a library that provides materials aimed toward persons younger than age 18. So if there are materials that are classified as aimed toward minors under age 18, that would be a portion of the library that would fall under that definition.
Yes, Representative Lean.
Thank you, Mr. Chairman. Thank you for that, Mr. Fuller. My follow-up would say, with the Cheswick amendment, then do we clear up the language that allows us to shelve this material in the adult section without penalizing the library?
Mr. Fuller?
Mr. Chairman, Representative Lean, I believe so. As long as it's not a portion of the library that would be devoted primarily to minors, the material could be placed elsewhere.
Representative Brady?
Thank you, Chairman. I just wanted to make a point that, for example, and I brought a book here that is often in a children's section. It is 100% illustrated, every page illustrated. For example, I just want to let people know, if they want to research some of these, if you typed in this book in Amazon, Gender Queer, clicked on that author, who is Kobabe, scroll down a bit and you'll see some information about the book. So if you scroll over and look in, for this book specifically, the reading age is labeled 18 years and up. That's considered an adult section in a library. But I want to also point out that that, as far as I'm concerned, there's no such thing as young adult in the library. You're either a minor or an adult. A young adult, according to healthcare providers, is 18 and 25. So just wanted to make that point.
So I let that go a little bit, Representative Brady, but let's try to keep it tight to the discussion of the amendment specifically. We have a lot of amendments in front of us, and if we get too far off track, then we're gonna be here later, but appreciate your comments. Let's just try to keep them tight to
Thank
the
you,
amendments.
Chairman. I just wanted to mention that. Thank you.
Thank you. Yes, Representative Webb and then Representative Kelly.
Just wondering about the word primarily in there. If the word primarily, doesn't that mean that's basically for adults? That one book isn't going to make a change in the whole, that section becoming a child section of the library?
Representative Kelly.
Thank you, Mr. Chairman. I think the point of contention here is the word "or." It says devoted primarily to or provides materials, and that's the gray area. LSO, if you can tell me, would it clear it up if we changed it to devoted primarily to and that provides materials? So it has to provide materials primarily to kids. We're very clear. It's not this or that. It has to be this and that.
I think that does the opposite and makes it, yeah, I think that puts us into murkier waters. I think it does the opposite of what you want it to do, because you would have to have I agree with Representative Webb's comments about primarily. If you take the Chestic Amendment and remove this other language, primarily is your gauge on whether it's a section for people under 18 or people over 18. If you then put an "and" on that, you're qualifying it to a greater extent that it can't just be devoted primarily to that section, but it has to provide materials aimed towards younger group as well. And I'm just not sure where that gets us, other than, I think the primarily is the gauge by itself, if you remove the other language. Senator Kolb.
Yeah, thank you, Mr. Chairman. So just a question on primarily. I'm assuming mathematically it's over 50% of the materials. Is that what it is? Is that a term of art in law? I mean, I'm not an attorney, so I'm asking attorneys a question. What does that mean in particular? Primarily, what does that mean? Thank you.
Senator Crago.
I think it's like 53.4% or something.
Oh, I can see we all passed math class here. Okay, so thank you.
I think reasonable minds may disagree, but reasonable minds may agree, and when they agree, it's more than 50%. All right. Any other discussion on this amendment? Yes, Representative Bratton.
Thank you, Mr. Chairman. I would like, now that we've had a little bit more discussion on this, including the term primarily, I would like to have LSO weigh in on that. Their fourth lawyer opinion.
Okay.
Thank you.
Do you have anything that you would like to add to the conversation, Mr. Fuller?
Yeah, Mr. Chairman, Representative Bratton, if primarily is not defined, you would look to a dictionary meaning of that word, and I don't have my dictionary here. A quick little search, though, defines it as for the most part. Mr. Chairman, I'd also note that we use the word primarily approximately 250 times in statute. I haven't had a chance to go through all of those, but it is a term that has been used as well.
And there may be a case, there may not be a case, we don't know, obviously, because we haven't done any research on that, but there could be a case that deals with primarily, I suppose, but any other discussion on this amendment? All right, all those in favor of the amendment signify by saying aye. Aye. All those opposed? I believe that amendment has been adopted. Division on the amendment. All those in favor, go ahead and raise your hand. 1, 2, 3, 4, 5, 6. All those opposed? 1, 2, 3, 4, 5, 6. Oh, all right. I guess my ears were a little off. That was a complete tie, which means it fails. All right. Any other amendments to page 2? Yes, Representative Chestic.
Yes, I have my amendment number 10 actually amends a lot of different pages. It starts on page 2. It has a lot of amendments on other pages as well.
Let me just ask if there are any amendments specifically to page 2 before we take on this larger amendment.
I'm willing to table this until after we've gone through the whole bill page by page and bring this up separately.
Because it's pretty broad.
It's comprehensive. It covers a lot of different pages.
Let's go through page by page, try
Okay.
to narrow it down, and then we'll circle back to that.
Got it.
No other amendments on page 2. Page 3? Any amendments to page 3? Senator Hicks?
Mr. Chairman, just looks at the staff comment towards the bottom of that page, but I think to address the staff comment in there, we can accomplish everything if we go to page 3 and you go to line 20. After contact, you would strike the word between 2 or more persons. So you would strike that out of that, so that then it would read pictorial or electronic form of sexual conduct by any one or more of the following. And I think that addresses the staff's comment on how that section F pertains to that definition. So anyway.
Okay, so your motion would be striking on line 20 between 2 or more persons onto line 21. And I heard a second by Representative Washit. And Senator Hicks has already discussed this motion. Is there any other discussion on this motion? All right, all those in favor signify by saying aye. Aye. Any opposed? Okay, that amendment has been adopted. Any other amendments on page 3? Okay, page 4? Any amendments on page 4? Senator Hicks, do you have an amendment or is your hand just stuck up?
No, I don't have an amendment, Mr. Chairman. I'll take that down.
Page 5. Any amendments to page 5? Representative Lean.
Thank you, Mr. Chairman. I would like to first address potential amendment number 2 from myself for this bill. It would amend page 5, line 2. Insert section 2, sexually explicit materials are cataloged, located, and stored in a section of the library devoted primarily to or that provides materials aimed towards persons age 18 and older. There's a piece of that comes in on page 4, line 28, after ensure that, and then just insert this.
Second.
It's been moved and seconded. Discussion, please. Let's start with Representative Lean to discuss her motion, and then we'll move to Vice Chairman Washit.
Thank you, Mr. Chairman. The intent of this is to make sure that we're properly cataloging the library books and that we're removing the library from if a patron picks it up in one section and sets it down in another, that this allows for those who would still like to check it out to know where to find it. Cataloging the sexually explicit materials in the adult section empowers the parents to be knowledgeable that there will be mature content in the book of which their minor is getting it off the shelf at.
Co-Chairman Washit.
Two points. One, the Romanet II, is that the right designator for that insertion? And secondly, I'm concerned about the possibility of a display having non-cataloged items put up in a children's section that may not be for checkout, but libraries oftentimes have public interest materials on kind of a kiosk display that may or may not be cataloged items. handouts, brochures, calendars, who knows, right? But I'm thinking about material that might be sexually explicit, but would not necessarily be a catalog book. So if we want to make the bill specific to books, I think the amendment works. If we want to be cautious about other kinds of materials that might be displayed in a children's section, then I think the amendment is problematic.
Mr. Fuller, do you want to address the first part of Co-Chairman Washet's question regarding Romanet 2?
Yep, so Mr. Chairman, Chairman Washet, this is currently a subsection B that starts on page 4, line 27. And the amendment, at least structurally, would split off everything after on that last line shall ensure that, and then it'd be a Romanet 1, and then that language would remain the same, and then the amendment would add a Romanet 2, which is on the amendment text itself.
Great, thank you. Any response to Co-Chairman Washet's question, Representative Lee?
Mr. Chairman, Co-Chairman Washet, I guess my question for LSO would be, would we be able to put in a quick provision on this amendment that might say something to the effect of materials stay in the adult section that are sexually explicit?
Mr. Fuller?
Mr. Chairman, Representative Lean, one possibility could just be sexually explicit materials are placed in a section of the library. I'm not sure if that directly addresses what you're looking for, though.
Representative Lean?
Thank you, Mr. Fuller. I would also just say that there's a lot of common sense that goes with this, and I believe that our Wyoming individuals are smart, and with the intent of the law to be that sexually explicit materials land in the adult section, I would hope that librarians hear us loud and clear to keep that sexually explicit material, whether it be a pamphlet or a flyer, a handout, a calendar, in the adult section when we're directing them that sexually explicit books are to be shelved in the adult section.
Yes, Representative Singh.
Thank you, Mr. Chairman, and not to belabor the point, but I don't believe that the amendment as described doesn't specify any parameters as to what a specific section would look like. And so all that's being asked is the distinction between what is sexually explicit for minors and what is available for adults. The amendment doesn't complicate that. If anything, it leaves that discretion to the folks that administer the library, if I'm understanding correctly. I'm seeing some faces.
Co-Chairman Washet.
Thank you, Mr. Chairman. So the amendment says that any materials are cataloged, located, and stored. So you're going to have all three of those. And so if it's a non-cataloged item, then it doesn't fit within that definition. That's my concern.
Any other discussion on this amendment? Representative Filer?
Thanks, Mr. Chairman. As I totally get this amendment, but there's one part of it that I have a problem with, and that's that aimed towards persons age 18. When we look at that age, 18 years old, I heard adult section, I haven't heard 18 and over section or up to 18 years old. But when we look at our statutes in Wyoming and the United States, a lot of them, what is 18? And I think that 18 is just sticking out to me. So 18 years old in Wyoming, you could sign a contract and get loans, phone plans, get sued or be sued. You could serve on a jury, vote, get married, change your legal name, make a will. There's a lot of things you can do at 18 years old. Because and I'm trying to stay to this amendment, the fact that it says 18, Mr. Chairman. You can be in the military at 18 years old without your parental consent at 18 years old. Here's the things you can't do as an adult at 18 years old. You can't drink or purchase alcohol, can't buy tobacco, can't even rent a car. You can't adopt a child, you can't purchase a handgun. There's so many different things that fall into this 18 number. But also in Wyoming, at age 14, you could be tried as an adult. As a matter of fact, I think one time there was a 13-year-old that was tried as an adult in Wyoming. At age 16, with your parental consent, you can get married. At age 17, with your parental consent, you can enlist in the military. So when we talk about adult section and then we say age 18, I think there has to be something that really defines that. Is this strictly adult section or 18? Because there's so many different laws that conflict with that age 18 and what is considered an adult in Wyoming and in the United States, Mr. Chairman. So I totally get the idea of the amendment. You know, that 18 number just keeps sticking out at me because there's so many conflicting laws on what an adult is, what an 18-year-old really is. You know, arbitrarily 18, I guess, you know, you could do this, but you can't do that. So is it truly an adult, Mr. Chairman? So I don't know how to change that language to maybe, you know, towards persons. I'm not an attorney though. I would ask Mr. Fuller if there's a way we can encompass to make sure that it's actually the appropriate section.
Mr. Fuller, do you have anything that you would add to that?
Mr. Chairman, it sounds, to me, it sounds, I'm not sure if it's necessarily a issue of language, it is an issue of policy. That would be up to the committee to decide if a different age should be specified there.
Senator Hicks.
Yeah, Mr. Chairman, I share Co-Chairman Wash's concerns. I know what the bringer of the amendment, and I appreciate the intent here, but I don't share the enthusiasm based on the number of emails and phone calls that I've got and the previous testimony that we've had from people affiliated with the county library system in the state of Wyoming, that they won't use this as an absolute loophole in certain cases to display material that's not cataloged. And so I think we just need to work on this. I think the issue is that Representative Lean brings is something we need to address. I just don't want to leave any loopholes here based on what we've had testimony on this by county library affiliates. And so I do share Representative Wash's concerns that we are leaving a loophole here for those that basically have told us to stay the hell out of their business anyway and let them do what they want. And so I think we need to be a little more explicit here with make sure that we clarify what our intent is.
Representative Lean.
Thank you, Mr. Chairman. Just to address the good representative's concerns over the age 18 aspect, in the library, we currently divide up our libraries by the children, young adult, and adult section, and that is a knowledgeable age 18. And so that is where the age 18 in this amendment came from. I just asked the committee to really take into consideration that we're asking to shelve this in the adult section so that the parents and guardians are empowered to know that there may be mature content within that book that they're still being able to check out for their minor child, or that their minor child could check out, because we didn't say they couldn't check it out. We're just asking that it be shelved in the adult section so that there is a knowledge for the parent or guardian that there may be some mature content within that book. Furthermore, for the good senator, I would ask that we work on passing this amendment, and I ask LSO to come up with a one sentence that maybe work in favor of this amendment to address the materials situation while we're currently working.
So Representative Lean, is that an amendment to your amendment?
Mr. Chairman.
Conceptually?
Conceptually, yes.
Okay. So is there a second on that? Okay, it has been seconded. Mr. Fuller, are you okay with the direction of what we're asking for with the amendment to the amendment?
Mr. Chairman, I think so. And I would offer, just off the cuff, two possible solutions. The first would be to just remove the word cataloged. And that would just mean that sexually explicit materials, regardless of whether it is part of the library's collection or not, are located and stored in that section. Mr. Chairman, then the other option would be, kind of as I just alluded to, sexually explicit materials that are part of the library's collection. Some language similar to that. So, Mr. Chairman, those are just two very quick options that I could offer right now.
Representative Lean, do you like either one of those? How do you feel about making that more concrete?
Mr. Chairman, my concern with removing the word cataloged is that the libraries will not give it the appropriate Dewey Decimal System to keep it in the adult section.
Representative Bratton?
Thank you, Mr. Chairman. I also have a concern that if it's not cataloged, one of the things we talked about was if you have somebody who moves it to an inappropriate section, and the librarians do have it cataloged in the adult section, so that this would protect them from somebody just moving the book back to the children's section, because their intent is they have it cataloged in the adult section.
Senator Cole?
Yeah, thank you, Mr. Chairman. So help me out with this a little bit. So we're missing the words possibly shall be cataloged. I mean, is that something we could add to it? Because we're saying there's a loophole by not cataloging it, and then it moving to a section because, you know, it wasn't cataloged. Would that help this? I'm just asking an open-ended question. Obviously, I come flat-footed to this, that I don't really have a clear understanding exactly of the issue brought up that is a loophole. So
I think Representative Bratton is saying if the amendment removes cataloged, then it creates that problem. Keeping it in is, in her mind, sufficient to answer that issue. It doesn't have to be a shall cataloged necessarily, but the issue is removing it.
Well, the issue is that if we didn't specify it shall be cataloged, is there a loophole? That's my question. So thank you.
Senator Crago?
Thank you, Mr. Chairman. I just wanted to point out, I mean, based on the proposed amendment, it already requires that they be cataloged.
That's what I'm trying to say.
Yeah, I mean, it's ensure that, and then number one, it applies to the children's section. Number two, Amendment 2 applies to the adult section, and it says shall be cataloged. So I think that's already in the bill draft amendment.
Representative Chestik, are you good, or did you have more to add? Okay. The lawyers agree. That's unusual. Co-Chairman Washit?
So just so I'm clear, so any materials that ordinarily would not be cataloged items, such as handout, brochures, pamphlets, those would now have to be cataloged or not allowed in the adult section of the library.
Mr. Chairman?
Yes, Mr. Fuller.
Mr. Chairman, I'm not sure if this Chairman Washit, if this would fully address your concern, but the language that's existing in that subsection B would work in tandem with paragraph 2. And so paragraph 1, if the amendment is adopted, would still specify that there can be no sexually explicit material accessible in the children's section of the library. I think the corollary to that would be that material, if it cannot be in the children's section, and the current language makes no distinction whether a material is part of the library's catalog collection or not. It's any sexually explicit material cannot be in the children's section. I think the corollary then would be, if it can't be in the children's section, it must be in some other portion of the library, i.e. the adult section.
Representative Lean?
Thank you, Mr. Chairman. Thank you for that, Mr. Fuller. So I would, for clarity purposes, take the amendment as presented by LSO, working in conjunction with that top paragraph that would become Roman numeral I.
Say that again, Representative Lean.
Mr. Chairman, thank you.
I'm not tracking.
No, you're okay. Take the amendment as presented versus any conceptual amendments that would change it.
So you're removing the conceptual amendment?
Yes, and given that Mr. Fuller mentioned section B, which becomes Roman numeral I, and that would maintain the placing of the materials in the library that are not cataloged.
All right, and Representative Bratton, you're okay with removing the conceptual amendment? Okay. We're back on the original amendment. Any other discussion on this amendment? Sensing you're ready to vote, all those in favor signify by saying aye. Aye. All those opposed?
No.
Okay, that amendment has been adopted. Any other amendments to page 5? Yes, Representative Chesick.
Please give me a little moment of grace here as I try and figure out. I had an amendment, number 8, that dealt with that same language, and I'm not sure that my concern has been addressed by the lien amendment that we just passed. My concern with page 5, lines 1, that whole section, starting on page 4 and going through, so the subsection B on page 4, line 27 through page 5, line 2, that whole section was problematic to me because it allowed for the possibility of materials that aren't owned by the library being planted there by some bad actor or being misshelved by somebody. And I'm not quite sure that the amendment we just passed solves that problem. So I'm going to move for discussion purposes, and I'm not sure I'm going to vote for my own amendment, but I'm going to vote for, I want to discuss this so we make sure we have this right. I'm going to move what was my amendment number 8. It's been distributed to everybody, where we delete that subsection B on page 4 through line 27 through page 5, line 2, delete that and replace it. And maybe this solves the problem that we were trying to solve with the lien amendment. The new language would be each public library, including employees and staff of the public library, shall ensure that all materials owned by the public library that are sexually explicit materials are not shelved in the children's section. I'm not sure it's similar to what we just did, but, or should I need some help here. Trying to make sure that we don't create a situation where somebody, a bad actor plants materials, or some other person, a patron, moves books from one section to the other. But that's my motion, and maybe we can continue discussing that.
Right, is there a second?
Second for discussion.
Seconded by Representative Filer. You'd like to discuss it? Go ahead.
I think, Mr. Chairman, thank you. I think the part of this amendment, it says each public library, including employees and staff, of a public library shall ensure all materials owned by the public library are, shelved in not in the children's section, right? So, but what I'm worried about is if an adult that is a member of the library actually takes that book and goes to that shelf, does that cover being able to not hurt any employee there? Because it just says, including employee, they shall, the staff, it's just, they shall, all explicit owned by the library. I just don't think in our shelved in the children's section, if somebody puts the book into the children's section, whose fault is that? It shouldn't be up to the employees. I read that as the employees will get in trouble still for somebody's negligence, Mr. Chairman. I don't know, I'm not an attorney either.
Well, and that's why we have a provision called the unauthorized practice of law. We don't let people who don't have law degrees practice law.
We do let them legislate, though.
Discussion, Co-Chairman Washer.
Thank you, Mr. Chairman. I continue to be concerned. I think there's value in designating here, because if a patron were to bring their own materials into the children's section while their kids are shopping, or if we're looking for a book or something, an adult just checked out their books and now they're waiting for their kids to pick their books. So I think there makes some value there, but I worry about a situation where, one, I'm not sure shelved is inclusive of all presentations. of different ways in which materials might be available in a children's section of a library. Might they be laid out on a table but not shelved, right? So that terminology concerns me a little bit. And then I also wonder about third parties being allowed to erect a display within the library that's not owned by the library. And if that organization were allowed to place that, then those materials aren't owned. So again, words mean things, and we have to wrestle with these.
Representative Lean?
Thank you, Mr. Chairman. I agree with the good chairman co-chairman about the third-party displays. In addition to that, in the amendment that we just adopted, it asks that library materials are cataloged, and that gives us the peace of mind that if somebody does pick up some of these books and take them to another section of the library while they're shopping in the library, or maybe they're going to play a game of chess like you do here at the Laramie County Library. You have an amazing children's section there. That you set it down with the intent of picking it up to check it out later, that they're not going to be in trouble because it's cataloged to that shelving area. And so I believe that this amendment provides us with a little bit of ambiguity when it says not shelved in the children's section, but it doesn't catalog them to that adult section.
Other discussion on this amendment? Senator Kolb?
Thank you, Mr. Chairman. Thank you, Mr. Chairman. So if it's not cataloged, though, so if we say it shall be cataloged, right? And if you have a book floating around in there, let's say it was brought in by some nefarious person who just wants to cause trouble, and it's not been cataloged and it shall be cataloged, is that some sort of defense, though, to say to the library that say, hey, we didn't catalog this thing and we're compelled by law to do that? And if it shows up, can you go to court and help you in your case to say, well, we didn't even catalog this thing, someone brought it in? Because that is a concern of mine that, we got bad actors running around here, causing trouble. But if it's not cataloged, is that a defense or not to having it show up in a library because say it was brought in by some other person?
Mr. Chairman? May we ask
Representative
Mr. Fuller
Mr.
to weigh
Fuller?
in?
Mr. Chairman, to an answer to Senator Kolb's question?
Yeah.
Yeah, Mr. Chairman, I think as drafted, and this is the existing language, that current subsection B that wasn't amended, no sexually explicit material shall be accessible in the children's section. As currently drafted, the bill makes no distinction of the source of the material. As drafted, I don't see in the bill a defense that could be raised to say that we didn't know or this wasn't part of our collection or what have you.
Okay, on the amendment, any other discussion? Any discussion? All right, all those in favor signify by saying aye. Aye. Any opposed? No. All right, that amendment has failed. Back on the bill. And we're on page 6. Or we're still on page 5? We got more on page 5. I'm sorry. Senator Kolb?
Yeah, thank you, Mr. Chairman. This is probably going to involve our LSO staff, but my concern is page 5, line 21, and it starts off on D, any interested party. My concern is that I don't want folks from other counties or other areas running into some other library or county library or whatever it may be that we're addressing here specifically and posing taking action. I believe that if you live in that said voting district, will it be for a school district or a county library, that you should have that should be the person taking action, any party within that group of folks, that they should be. I do not want other people coming in from other states and other areas filing suits against the library systems or in this case, county libraries or school district libraries. I don't want that to happen. So I think that if we're going to have people that file action against these people with what they can do in this bill, that they should be a resident of said voting district. I realize there's a difference between school districts broach counties, right? We have it in some areas.
Well, Senator Kolb, I think you could say something like any interested party who is a resident of the county
affected
where the library is located.
Okay, well, that would.
Something like that.
That would, and maybe we could work on that with LSO, but that's in concept, the amendment I would like to propose.
Okay. Let's see if there's a second on this motion. No, sir. It's been seconded. Okay, Representative Chesed.
I was just going to point out that there are two amendments in the packet that have been distributed that deal with this issue. Representative Lean has an amendment that changes interested party to say who is also a resident of Wyoming. I have an amendment which changes interested party to a parent or guardian. So we have amendments coming up that address this issue.
Mr. Chairman, this isn't the amendment that's been moved and seconded.
Do you want to continue?
I do.
I'm assuming you want to continue.
I don't like, frankly, I don't like the other amendments. Okay. I mean, some of them I'm all right with, but I'm proposing this because I'm aware of that. So thanks for the, I guess, comment, but I still want to move forward with this because I think it's germane and it gets to some of what some people have talked about, and that's why I proposed it. So thank you for, I guess, telling me we have amendments.
Okay, so Representative Lean?
Thank you, Mr. Chairman. Just for a little bit of clarity on the good senator here, for the county side, could it potentially say on lines 521, after interested party, county residents, and then on the school side, it would be page 6, line 18, district resident? Would that give the clarity that you're looking for? So that if you live within the school district, because there's multiple school districts within multiple counties sometimes.
Mr. Chairman?
Yes. Senator Cole?
Representative Lane, yes. That's what I was trying to get at, is that it's more complex than saying any county. I mean, in my mind, it's more complex, but that was something to be worked out by LSO, maybe with the direction of the chairman, and Mr. Fuller could look at it and clarify that language or make sure the language that we're going to talk about is appropriate and works in this bill draft. But I just don't want it to be so broad, anybody anywhere is going to bring suit against somebody. That's my concern, and we're going to have folks. I respect people's opinions in these districts, and they may be very different in different districts. So that's the reason why I think we're all thinking about the same issue here, is that I just want to put sideboards on it. That's my goal.
Mr. Fuller?
So, Mr. Chairman, Senator Kolb, public libraries are generally creatures of a county. And so I think it would be acceptable to say, in that instance, any interested party who is a resident of the county in which the library is located. And then similarly for the school districts, it would be any interested party who is a resident of the school district. And I may tweak that language slightly for clarity, but that's the general upshot.
Mr. Chairman, that's exactly what I meant to say.
I agree with that.
Yeah, I think this is a really good amendment. I think it narrows, I like the Wyoming resident amendment as well. I know that it's not the amendment we're talking about, but I think this is, narrowing it even more is a prudent step. Representative Lean?
Thank you, Mr. Chairman. I agree with Senator Kolb on this one because the good representatives that elect their officials in one county of the state may not be what the needs are of a county of another state. And so I do recognize that the potential amendment that I had may have offered for an individual from across the state that doesn't recognize the county needs or the school needs to be different.
All right. We may have some consensus on this. All those in favor signify by saying aye. Aye. Any opposed? That amendment has been adopted. And any other amendments to page 5? Representative?
Mr. Chairman, would you just repeat the language, the exact language of the second part of that, with the school district?
I think that's the language that Mr. Fuller might play with a little to make it
Okay.
work, but it basically saying that you have to be a resident of the school district.
Okay, thank you.
Sorry, Representative Kelly, go ahead.
Thank you, Mr. Chairman. On page 5, line 4, it says, if any person violates, I'd like to delete on line 4 the word person and insert employee or contractor of the library. So, and also on lines 6 and 7, strike $50,000 and insert 500.
Is there a second? Second. Okay, it has been moved and seconded. Discussion on this amendment?
Can I ask a clarity question?
Yes, Representative Lean, go ahead.
Thank you, Mr. Chairman. Just for clarity purposes, with the language, does it need to be staff or the language that you said with the contractor?
Mr. Chairman, it says later in there, it says that employees or contracts, so I figured employee and contractor would cover that. But I'm open to putting the word staff if that makes people feel better.
I think if I heard you right, did you say if any employee or contractor of the library violates subsection B? Is that what you said?
Yes.
Okay.
Mr. Chairman, might I
Yes.
ask Mr. Fuller, does the contractor also include the volunteers that may come into the library, or does that need to be, is there a specific word to include all encompassing of everybody that works for the library?
I don't think it does. Mr. Fuller?
So, Mr. Chairman, I'm not sure how those relationships are structured, but I would generally not consider a volunteer to be a contractor or an employee.
Right. Did you raise your hand, Representative Kelly? Sorry, go ahead.
Thank you, Mr. Chairman. I would resist the word volunteer for one reason, and that is because volunteers are hard to come by in public libraries. I wouldn't want to do anything that would make people hesitant to want to volunteer to help in their libraries because they might fall under this. Ultimately, what our job here is to provide an avenue for parents to have better control over what's going on in their communities, but we don't want to dissuade people from community service.
I think Representative Lean shares your concern. I think she's trying to make sure that they're excluded from this new dischange of definition, which I would agree with as well. There are a lot of children, for example, who serve, high schoolers and junior high schoolers who serve in their libraries on volunteer capacities, and I don't think the aim would be to try and rope them in. Senator Craigo?
Yeah, Mr. Chairman, I just want to point out one of the inconsistencies in the bill. So if you go back to page 4, it says employee and staff. Staff, in my mind, would include volunteers. We're not using that identical language on page 5 when we get over there. So just throwing that out there, something for the committee to think about.
Sounds like we could make that conforming amendment to clean up that language with your amendment. If you want to, at least. We can revisit it separately, but I think that is definitely worth addressing. What line is that on, Representative Craigo? I'm looking, I found it, line 27. Would you like to include that in your amendment? Representative Kelly, so that line 27 would read each public library an employee or contractor of a public library? Okay. Who was the second? Remind me. Are you okay with that? Okay. Co-Chairman Washit, go ahead.
Thank you, Mr. Chairman. So in the event that a library that's trying to sidestep this bill, if it were to pass, and they had their staff or their volunteers be the ones who put these materials in the children's section, have we now carved out the liability by not including the staff and volunteers?
No, I think I would respond to that with if that's the case, then an employee or a contractor gave a direction to a volunteer, and the provision says that the employee or the contractor shall ensure that there's no material there. So by giving that direction, they violated the provision, I would argue. I think the only scenario that would, you're either gonna be directed by somebody who is directly employed or contracted by the library, or the volunteer is going to act on their own volition. And if they act on their own volition, then they are not liable, and the library is not liable. That's how I would read it, Co-Chairman Washut.
Very good.
Representative Filer?
Thanks, Mr. Chairman. And I think if the bringer of the amendment would be okay with this, but I think we can cure some of this. Again, I'm not an attorney, that's why I lean on you guys quite a bit. But if we do look
We're
at
going to
page.
start charging if you keep leaning on us
Hey,
like this.
anybody needs free legal advice, this is how you do it. No, but, no, so if we look at page 4, lines 27, that B, it says each employee or each public library and employee, if we delete after employee and staff of the public library, and then just keep shall ensure that no explicitly materials go in there, but what that does is it eliminates that volunteer, so now it's has to be an employee of that public library, because volunteers aren't employees, right? Contractors could be considered employees because you actually employ those contractors for that public library. I just think if we delete lines 27, that and staff of public library, might help with some of that, wondering who, if a volunteer's an employee or not, or I don't know. Again, these are terms that, attorneys use to litigate, so.
I would say let's take it one at a time. Let's finish up with Representative Cayley's motion that is at least consistent with both parts of his motion. And then if you want to make an additional motion to revisit language on page 4, we can do that.
Okay.
That way we don't get too off track with the purpose of the original amendment, that is what I'm worried about.
And Mr. Chairman,
Fuller.
just to make sure I'm properly tracking the amendment, then this amendment would still include the change to say an employee and contractor of a public library. Okay, thank you.
Correct. Any other discussion on this amendment? Representative Webb? Turn on your microphone there.
Thank you, Mr. Chairman. So I need to be square on this.
Okay.
Is a volunteer an employee, or is a volunteer, like the co-chairman said, going to be able to come in and violate this whole law that we're trying to enact?
So under the amendments the amendment that we have in front of us, a volunteer, the provisions would only apply to employees or contractors. And so neither an employee, a contractor, nor a public library would be responsible for what a volunteer does or doesn't do under the current provision. The volunteer would be on their own. So volunteers would individually not be liable, and the public library would not be liable for a volunteer. Well, for a volunteer's actions.
Who would be liable for the volunteer's actions?
The bill would not impose any liability on a volunteer. We've excluded them. The policy choice that you're gonna make right now, Representative Webb, is in part, is whether you want to exclude a volunteer from liability. That's part of what the motion does. The other part of what the motion does is the original intent on page 5 of the amendment, which we've walked away from quite a bit.
Okay, thank you.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Well, to the bringer of the amendment, what's going to stop a library from bringing in volunteers that do exactly what we're trying to stop here? To have conversations they shouldn't have in a public setting. What's going to stop that? What's going to stop that from happening? I mean, I get the counter argument that you made saying, well, we need volunteers. Well, you're right, we do. But I look at loopholes and I look at people that are frankly nefarious actors, and to just basically circumvent whatever we're doing here. So what's going to stop them from doing that? That's my question to the bringer of the amendment.
And I would actually, I would back up to what I just said. I want to clarify that now that I look at the language on page 4. The language on page 4 says each public library and employee and contractor under the amendment. So the public library must ensure that no sexually explicit material is accessible to children. So the public library cannot bring in volunteers to subvert that because they have an obligation under it. The employee has an obligation, the contractor has an obligation, and the public library has an obligation. That help, does that alleviate some of your heartburn?
Mr. Chairman, thank you for the attorney. I expect to see a bill.
Okay. All right. Representative Lean.
Thank you, Mr. Chairman. To the bringer of the amendment, I just might ask, why such a drastic change to $500 from $50,000?
Back to the original meat of the amendment. Representative Kelly?
Thank you, Mr. Chairman. $50,000 just comes across as punitive. It's untenable, maybe for smaller districts and libraries. My understanding, the purpose of this bill is to empower parents and communities to have more control over what's in their libraries, not to punish libraries or shut them down or punish librarians. So if we have a cause of action for parents if they find something that there's an issue, and with later amendments for a review period, what we're allowing is parents and communities to have better control of their library. It doesn't really matter what the dollar sign is here, because also in the bill is included that they can recover their attorney fees. And ultimately, with a review period, we would be encouraging local libraries and school libraries to be responsive to their communities rather than closed-eared and say we're the professionals, because they would want to avoid the lawsuit. And we don't have to have this heavy-handed $50,000 fine hanging over them. It's just the threat of a lawsuit if they are unresponsive to communities. That's the incentive. I think that's enough.
And Representative Webb, I just want to circle back to you because I told you two different things. But the last statement that I made, I want to make really clear when you're voting on the amendment. The public library is still responsible for what a volunteer does or doesn't do. But the volunteer individually is not liable. Does that make sense?
Yes, and that's what I understood with your last clarification. Thank you.
Back on the discussion of the civil fine. Any other discussion on this? Senator Culp.
Yeah, thank you, Mr. Chairman. Just to the bring of the amendment for changing it. Did you consider a stepped approach? In other words, 3 strikes, you're out kind of thing? Well, you get, two shucks and one $50,000 fine. I don't want to see repeat issues with violating the statute. And there are going to be some districts that maybe are going to make the decision they don't care about $500. And you're right, some other ones care a whole lot about $50,000, but a stepped approach. In other words, we do that with a lot of things. There's, misdemeanors and felonies, right? So what did you think of that at all? Or what's your thoughts about a stepped approach on a fine? I do agree with your lowering it for the first offense for sure, but what are your thoughts on a higher amount for subsequent violations?
Representative Kelly.
Thank you, Mr. Chairman. I'm open to that. I'm not married to the number 500. I just wanted to make the point that 50,000 was egregious.
Okay, on the amendment, Representative Bratton.
Just a point of clarification, that's 500 per violation, is that correct?
Yeah, Representative Kelly. I think the only change was to the dollar amount. Other discussion on this amendment? Representative Brady?
Thank you, Chairman. Even from a constituent, they were satisfied with lowering it to at least 5,000. So I'd like to propose that instead of 500.
Okay, let's take this amendment up first, and if it passes or fails, you can make your motion if you want to. Any other discussion, Representative Feiler?
Thanks, Mr. Chairman. I think, that number, 500, there's other states that have done this too. And I've talked to some of those folks that helped work that legislation in other states. And it was even down to $250 in a state next to us, right? And I think the main thing is it was more of the litigation side of it. It wasn't actually the fine itself. It's the fact that they have to go into litigation to fight arbitrarily a $250 fine or a $500 fine or a $50,000 fine, whatever that number might be. So what that is just more, I think the litigation side of it's more the deterrent than the fine. And, you know, just pointing that out, Mr. Chairman, and that's why I seconded that amendment.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Just about the litigation cost. You just settle it for the amount of money. Let's be clear about this. No one's going to pay an attorney cost you more than that for an hour, especially the attorneys we have here. And because of that, they'll just settle. So I think that there has to be a number probably that's floating in between there, because $500, no one's going to go to court for $500. I mean, not the attorneys that I've ever hired. So, thanks.
Representative Filer?
And Mr. Chairman, if that was true, which I do believe that, you know, probably would go down that path, but that would, you know, once you go to a library board or your county commissioners or whoever's in charge of that library system there, and you have to keep explaining to them, why do we keep paying these? You know, why are we, you know, the questions start to get asked by the boards and stuff like that. They're like, oh, we need to make these changes. We're not going to keep just paying $500 or $200 or whatever that fine ends up being. Over and over again, but it actually allows that board to actually get that report and knows where that money's going and gives them a little bit more oversight of what's going on within their county libraries.
Co-Chairman Washit?
Thank you, Mr. Chairman. So in my conversations with the individual who is very much involved with getting similar legislation passed in our state to the west of us, where the penalty is $250, they've had very desirable results in their legislation, even with that low dollar amount, that it was the litigation hassle, let alone the fees of your attorney, because you're not only paying for the representation of the affected body, but you also have to pay the fees, reasonable fees of the opposing litigant. So I don't think we have to get crazy with the dollar figure to have the desired effect. That wasn't the result in our neighboring state.
Representative Lean?
Thank you, Mr. Chairman. In the conversation about the fine cost and then the potential for the courts to be able to grant attorney fees, later in the bill on page 5, line 22, and then again on 25, it says the courts may order an injunctive equitable relief or damages, cost, or fees. Shall we make that a shall if we're going to lower the fine, so that the courts know that if this is a verdict, that they then are responsible for issuing the court fees back to the plaintiff?
Mr. Chairman.
Hold on, Mr. Fuller. If you were going to adjust that language, you would not want to make the entire sentence a shall if you wanted to require that attorney fee. You could have a separate provision that says, you know, attorney's fees shall be awarded to the prevailing party or something like that. But this other language, you want to, the court may order an injunctive or equitable relief, for example, you want the court to have permissibility on that based on the circumstances. That's not addressing you're concerned with the award of damages and costs and fees. So I think that would be you'd have to write that somewhere else. Mr. Fuller?
Yeah, Mr. Chairman, I just want to make sure the distinction between subsection C and D is clear. Subsection C, which is currently the topic of the amendment to change that civil penalty. Mr. Chairman, a civil penalty is something that the state, by and through either the Office of the Attorney General or the county attorney, would have to seek to recover. Subsection C does not concern the lawsuit that, and as amended, a county or school district resident could bring and then seek the attorney fees. So that is two separate issues. So I think the only question here is really the amount of the civil penalty that may be recovered by the state, whether through the Attorney General or the county, for violations of this act.
You could still award it to Representative Lean's concern. You could still have an attorney's fees award even if it's the state or the county bringing the action.
Mr. Chairman, I would need to double check the other statutes. I believe costs could be assessed against the library in that action. But they are still two separate issues. An individual person would not bring an action for 200, or as proposed, $500. They would bring an action for separate damages that they would prove, as a result of the violation of the act. And then under subsection D, as noted, as currently drafted, that does allow a court to award that individual person attorney fees and costs if they are a prevailing party.
Okay, thank you, Mr. Fuller. Let's tighten this up so we can talk about attorney's fees if we want to, but let's tighten it up right now to the civil penalty. Mr. Co-Chairman?
Thank you, Mr. Chairman. So I appreciate Mr. Fuller's comments there. So the civil penalty would be the county attorney suing the county library to collect a $500 damage. I don't see that happening. And if you sue the school district, the $500 penalty would go to the school fund, right?
So Mr.
So I'm just thinking that maybe paragraph C is a little less than helpful.
Mr. Fuller?
Yeah, Mr. Chairman, I was just going to say, Chairman Washut, whether it's a public library or a school district, a civil penalty that is imposed and collected under Article 7, Section 5, and then in Wyoming Statute 81109 would go into the school fund of the county.
All right, any other discussion on this amendment? All right, all those in favor signify, whoa, yes, Representative Chesed.
Could I ask for a division on this one? We have some language
Yes.
changes on line 4, that I want to have that as Division 1, and the dollar amount is Division 2.
Okay, it is definitely divisible. Which division would you like to take up first?
For the first one, the language change, you can just vote on that. I think we discussed it.
The language, I'm sorry, which one?
Line 4, the language change to employer contractor.
Oh, page 4, line 27?
No, page 5.
Page 5. Oh,
Page 5, line 4.
Okay, that's your first division.
Yeah.
And now tell me what your second division is?
Is changing the dollar amount to $500 on line 7.
So where does the language on page 4 go? With your first division?
The motion was to change the language on line 4 to employee or contractor. That's the motion that I want to vote on separately from the dollar.
No, the
amount.
motion also includes a change to page 4, line 27. So I want to make sure that's,
Yeah,
is that a separate division or is that part of Division 1?
That's Division 1.
Okay, I got you. Okay, so Division 1 is all of the language dealing with employee and contractor.
Right.
Okay. Discussion on Division 1?
Are you sure? Might want to get with Representative Kelly, but was page 4, line 27, was there an amendment on that? Or was it just page 5, lines 4 and line 7?
No, we went, the mover added in page 4, line 27 to make that language consistent with the language that we're adding in under the original amendment.
Okay, thanks, Mr. Chair.
So it's different than what you, yeah. My memory is bad, but it's not that bad. All right, any other discussion on division number 1? All right, all those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted. And now we're on division number 2, the civil fine being reduced from $50,000 to $500. Any discussion on division number 2? Okay, all those in favor signify by saying aye.
Aye.
Any opposed? No. All right, that amendment has been adopted. So, and with that, we are going to take a break. We'll take a 15-minute break and we'll be back at 10:30. And sing again. All right. Thank you, committee. I'm sure that break was much needed. I know it was for me. So with that, we can get back on. We were ahead of schedule, and I think we're moving along at a good pace, given the complexity of the topic that we're dealing with. So I'm just delaying my language for a couple of minutes here while Representative Filer gets in his seat. Oh, you're confusing the House with the Senate. I see. The Senate always starts on time. Okay. Page 5. Were there any other amendments to page 5? Yes, Representative Chestick.
Thank you, Mr. Chairman. I'm going to propose half of one of the amendments that I have been published. It's amendment number 3. The first half are all on page 5, and they're dealing with the same two sections that we were just amending and talking about a moment ago. So as long as we're on that subject, I thought I would propose all the page 5 amendments, the top half of amendment number 3 of mine. Page 5, line 8, just clarifying, it's just adding language that says that the penalties, the civil penalties are collected, just to clarify where that this money goes to the state. It's not going to go to any private plaintiff, whatever the fine ends up being. And the page 5, line 21, I want to change the words interested party to parent or guardian whose child has viewed sexually explicit materials in the section, children's section of the library. So this is in part D, which is the private cause of action for individuals who might want to seek relief for violations of this statute.
Those are sufficiently different. Can we take them one at a time?
Yeah, that makes sense to me. It does.
Do you have others, or is it just those two?
Well, the rest of the amendment actually deals with D. So let's do the page 5, line 8 first, the clarifying language. We can deal with that, and then the others are all related to the other topic.
And
sounds good to me.
Mr. Chairman?
Yes.
I think the way it would be divided, it would be the two changes, so it'd be page 5, line 8, and then page 6, line 16 would be a first division.
Okay.
Okay, that makes sense.
Got it.
I would move that.
Okay, that has been moved. Is there a second? Is there a second? Is there a second? All right, that motion fails for lack of a second. Would you like to move your second amendment?
Second amendment, and we can deal with, so again, the bill deals with both public libraries and school libraries. We're on page 5, the page 6, it's identical changes. We can deal with them both now, I guess, if you want to do that. And that is to clarify that the private cause of action that is authorized by the statute, and I guess I'll move them both, page 5 and page 6, where we're authorizing a private cause of action where the only people allowed to file suit will be parents or guardians whose child have viewed sexually explicit materials in the children's section of the library or in the school library. And the only thing they're allowed to claim are actual damages. That's the change on page 5, line 23. Award actual damages in an amount equal to the damages incurred or suffered by the plaintiff. I'll move that on both page 5, line 23, and on page 6, line 18 through 21.
Where's the, the damages portion, is that's line 6, 20, 21?
Yes.
And you want to use the language actual damages?
Yes. We're inserting the word actual damages on line 20, and page 6, line 20, award actual damages, and then we're defining that as in an amount equal to the damages incurred or suffered by the plaintiff.
All right, I'm tracking. Is there a second? Is there a second? Is there a second? All right, that motion has no second, has failed. Any other motions to page 5?
Mr. Chairman?
Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Page 5, subsection C, strike the entire subsection. I find it, after learning more about this, that we're just funding school districts with any said fines, and I don't know if that's really in our best interest. I'm more interested in the other sections, D, let's say, with individuals.
You could specify where the fine goes. It doesn't have to go to the common school fund. You could direct the funds anywhere you want them to go.
But not to an individual.
Under any section where there's costs paid by a party, the legislature has the ability to basically appropriate those funds to whatever we want to appropriate them to.
Wouldn't that
I'm
be,
not trying to change your motion, but I'm just letting you know that we
could direct
you
it
can
to
direct
other
it.
places?
Yeah.
All right, well, thank you for the clarification. I thought we were trapped in giving it to that purpose. But if we keep the interested parties on D, though, and I just don't know, my motion still stands. I think it cleans the bill up a lot, just to say that.
You changed that.
What's that?
On D?
No, we're not on D. I'm just talking about C right now.
Oh, okay.
Stripping C.
Okay.
That's, and I'll certainly open it up if we get a second for further debate on this.
It's been seconded to remove subsection C. Yes, Co-Chairman Washut.
Mr. Chairman, so don't we have a constitutional amendment that requires fines go to the school fund?
Mr. Fuller?
Yeah, Mr. Chairman, Article 7, Section 5, and then Wyoming Statute 81109 does require fines and penalties to be deposited in the school fund of the county.
So absent changing that other statute, we couldn't direct the funds?
And Mr. Chairman, once again, this is, I think, only talking about the civil penalty, not the private cause of action. But Mr. Chairman, I believe the Constitution would require the fines and penalties to go to that school fund.
Well, then I modify what I said earlier.
Well, I need a rebate on my last charge then for council. Thank you.
It's a 50% discount.
50%.
Any other discussion on this amendment? Oh, Senator Hicks.
Yeah, Mr. Chairman, just something to consider depending on the disposition of this amendment, but you could also withhold funds rather than just fine them. In other words, you could put language in there that would withhold those fines through the school foundation block grant program to any individual district, and same thing for county libraries could be withheld through their local government distributions. Just another potential alternative to get around this issue of fining and moving from one hand to the other.
Any other discussion? Representative Lean?
Thank you, Mr. Chairman. I might ask the good senator, might we be able to relocate that monetary penalty into section D as a portion of your amendment?
Senator?
And Mr. Chair, that'd be up to you, Representative, if you wanted to move that. I guess that's an LSO question. If the chairman so decides, or maybe we have expertise that knows more about that.
So Mr. Fuller, did you catch that?
Yep, so Mr. Chairman, I think what Representative Lean would be asking is if there should be just either a set amount or a minimum amount of damages that would be available for a person who brings an action under subsection D. I believe that's the question.
All right, in which case we would still, even if we did that, we would still delete subsection C if we were going to do that. So I think that can be a subsequent motion. Senator Craigo?
Thank you, Mr. Chairman. Just a follow-up question for Mr. Fuller on, just looking at Article 7, Section 5, for example, municipal fines, right? If you violate a municipal law, the fine goes to the city, correct? It doesn't go to the school, it does not go to the school account. So how does that interplay? And this is just, I'm just inquiring because I'm a little curious.
Yeah. Mr. Chairman, Senator Crago, I'll pull up Article 7, Section 5. I believe it says all fines and penalties under the general laws of the state. And I think that may be where the distinction is with municipal ordinances. Those aren't general laws of the state.
Okay. Any other discussion? All those in favor signify by saying aye.
Aye.
All those opposed? All right, that amendment has been adopted. I think we just undid the last half hour.
I would propose the amendment sooner,
Should,
Mr. Chair.
I'm gonna call on you from now on if you're gonna do stuff like that. Representative Lean.
Thank you, Mr. Chairman. I would like to move proposed amendment .5 for page 5, starting at line 3. And it works through the ability to put in a review process locally at each library. I would ask for conforming language for the county residents since we adopted that, and for the school district resident since we adopted that amendment as well. The one change I would make to the printed review would be to go to 60 days instead of 30 days, as I've spoken to some librarians and know that that might be a bit of a challenge to get that 30-day process reviewed. In addition to what's printed on this amendment, I would like Mr. Fuller to create a section at the end of it that would create a penalty for not having a form completed by August 1st of 2026 that would be $500 a day until implemented.
Is there a second? Seconded by Representative Brady. Discussion on this amendment? Yes, Representative Lean.
Thank you, Mr. Chairman. This amendment gives us the ability to give the local control to the libraries with the implementation that we are putting sexually explicit materials being cataloged into the adult section. It also gives them a chance to review the process before any court action is taken and gives the public a chance to weigh in.
Any other discussion? Yes, Representative Chesick and then Representative Filer.
Thank you, Mr. Chairman. And while I appreciate the concept of this amendment, I have one that's very similar to this, which I'm going to be bringing later on. I think I'm going to vote no on this one because it lacks a couple of things that are really important. And one is an appeal process. And it also lacks standards for how the collection policy needs to be promulgated and implemented. I think the amendment that I'm going to be bringing later on is more comprehensive and it does cover those topics. I also object to the language of any person may challenge the inclusion. This is on the first paragraph. May challenge the inclusion, placement, or presence of any sexually explicit materials. That's too broad. It covers some patron brings in a hustler and leaves it on the table. It's not any fault of the library, but that is presence of sexually explicit material, which results in liability. So I think it's too broad. For those reasons, I would oppose the amendment and encourage support of my similar amendment later on.
Any other discussion on this amendment?
Mr. Chairman.
Oh, sorry, I forgot Representative Filer. Go ahead.
Thanks, Mr. Chairman. And with this amendment, I think there is a lot of libraries that already have some processes like this now. So I think it's a really good idea. I do believe in the 60 days, the written electronic receipt. And then also, I think there's another, I don't know if Representative Lean did, there's another one on the backside of that amendment where I believe for school district from 30 to 60 also, if we can make those the same. But other than that, I think it really, in a way, kind of just allows that that policy to be set up within libraries where you do get public comment, where the library boards get together, there is something that is challenged by a parent or whoever. It gives that county library board some options, and also it doesn't start with a lawsuit right away. You know, it gives them that time to actually look at that, get the public comment and all that, Mr. Chairman. So if, you know, we can make that 60-day change on both sides, I think. For the most part of this, I think is pretty well written, because I think a lot of libraries are already starting to do this anyway.
Representative Lino, are you okay with that 60-day change?
Yes,
In
Mr.
both
Chairman,
areas?
and thank you to the good representative for 60 days in both places, school libraries and county libraries.
Okay. Any other discussion on this amendment? Yes, Senator Craigo.
I guess just a question for the bringer, and maybe you can help clarify, and maybe I'm just missing it, but if a challenge is brought, library accepts the challenge, they look at it and they agree, and they remove the book or material or whatever, I mean, I'm saying book, but if they remove the book from the children's section, can a lawsuit still be brought? Because I'm not sure that's entirely clear in the amendment. It says you have to go through the review process first, but I don't know if it says if the book is actually moved within the library that an action can't be brought.
Representative Lean.
Thank you, Mr. Chairman. To the good senator, I believe that when we have the libraries implement this review process for the books to be able to be challenged, that they have the local control to be able to say what moves forward and what their review would be. So in the event, kind of like promulgating rules, after we create a law, there's rules that come with the intent is to move it, that it shall be shelved in sexually explicit materials, shall be cataloged and shelved in the adult section. And if you have a challenge process brought before them, they need to move it. If I need to amend this to require them to move it upon findings that the process gives us a book that is sexually explicit, I'm happy to amend it further.
Yeah, I think you just need some simple language that says that any material that, any explicit material that was properly placed or removed, or whatever the magical language is, relocated, I think it's an easy fix, Mr. Fuller.
So Mr. Chairman, I think what I'm hearing is the language would be something to the effect of no lawsuit or cause of action shall be brought under this subsection if a successful challenge is brought under what would be subsection B of this section. If I'm hearing correctly, if the challenge is, the question would be if the challenge is successful and a material is moved or removed from the children's section.
Yeah, maybe I would almost say that language should say successful challenge and it's remedied, or the material is moved, something that makes it very, very clear that the library mitigated its liability by removing the item.
Preempts the cause of action.
Senator Kolb?
Yeah, thank you, Mr. Chairman. I think that solves a myriad of issues. It actually gives people a chance to resolve the issue without a fine. And if they don't, then we can talk about a fine and probably stiffen the fine up, because there's a mechanism here that we can let them take care of the issue in-house. And there really nothing else is needed. What's that?
You removed the fine.
Well, I know, but I'm talking about in the next section.
Oh, okay.
The next section.
All right.
Yeah. Well, the fine that went to the school districts, yeah, I didn't think that was a little bit circular. But this issue would be is we allow them a chance to mitigate the issue, and I think that's fair. I think that's a fair way of handling it.
Representative Lean, are you good with that?
Mr. Chairman, if I need to make an additional motion to allow for the amendment to the amendment via Mr. Fuller words, yes.
I think if the mover and the second are okay with it, we'll just adjust the amendment. Are you okay with that?
Yes.
Representative Brady? Okay. And Mr. Fuller, you're good now? Okay, and now we're still back on the motion, Representative Chesick?
Still on the same topic, I think I have language that might solve this problem. It's in my amendment, but if we can lift it from my amendment and put it into your amendment, that might solve the problem. It's in my amendment number 10 on the, where I was proposing, boy, this is part of the, so on the second page, there's no line numbers on this, but I'm inserting a new section under page 5, line 27. I'm looking in the middle of the second page here under Romanet 3. This covers the same topic, and maybe this language will fit into the amendment that's now on the floor. If a public library corrects violations of subsection B of this section, and that might need to be adjusted, the numbering there, through the reconsideration of the materials process, the appeal process we just described, the public library shall not be subject to, and I would change that to liability, specified in subsection D of the section, or subsection C. Actually, C was eliminated, but C is now the civil cause of action. So that subsection C is correct now that we've eliminated the fine. That now refers to the civil cause of action. Does that language solve the problem?
I think that the language, I don't think so. I think the original language is a little more on point. This one, talking about the civil penalty, and, I mean, we're saying, I think we're trying to accomplish the same goal, but I don't know that your language gets us any further than what Mr. Fuller came up with already. So I would just urge to stick with Mr. Fuller's amended language.
Yeah, just point of order.
Yeah, Senator.
Yeah, just, I think, are we proposing an amendment to an amendment? And if so, that needs to be proposed, and then it needs to be seconded. I think that's kind of, we're getting, I mean, just from my point of view, it's, I don't mind discussing it, but I think we have to have, an amendment to an amendment at least to discuss this, Mr. Chairman.
Okay, thank you. Any other discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed? All right, that amendment has been adopted. Other amendments to this section of the bill? Yes, Representative Chesick.
I know where this is probably going to go, but I need to make the motion anyway. We talked about early on a global amendment that we were going to discuss later, but we've already talked about the one that parallels mine, so I want to bring mine up now. The entire amendment number 10, which covers both the public library and also the school libraries. It covers the same territory of the amendment that we just adopted, but I would recommend this as a substitute amendment. And so basically, my motion is to repeal the amendment we just passed and replace it with this one, which covers the same material in I think, a more comprehensive way. So that's my motion, and if it's seconded, I'm happy to discuss.
All right, heard the motion. Is there a second? Second? Is there a second? All right, that motion has failed for lack of a second. Any other motions to this area of the bill? We are on page 5. Yes, Co-Chairman Washut.
Thank you, Mr. Chairman. I don't have language, but one of the issues that's been raised in some of the emails I've received dealt with this idea of awarding damages. And how would that be calculated? What exactly is the damage? How do you put a dollar amount on a child seeing a particular page of a book? And then in addition to that is this whole question of, is there one cause of action for one book? Or if 10 children have seen the same book, now you have 10 causes of action, potentially. And how do we want to manage that as a committee? I don't have an amendment off the top of my head, but I think maybe a specific amount of damages being statutorily set might make it clear that there's some damage to be awarded, as opposed to putting it on the plaintiff to actually prove what's the dollar amount damage done when my child sees the book. So I'm open for thoughts from the committee, but I don't have specific language for an amendment.
I think the damages would be calculated, it's very similar to generally most causes of action. The plaintiff has to prove damages. That's part of their burden. And the plaintiff would have to prove and would put forth evidence of what those damages are. I don't know what all they would be, but like, for example, it might be that because of the book that my child saw, my child was, very confused and distraught, and I enrolled my child in counseling, and so I have counseling expenses, just as an example. So you're gonna have actual damages that are actual monetary damages that are gonna result from something similar to that you're going to have to prove to the court, just like you would in any cause of action. Senator Crago?
Or not, if the book's removed, right? If the book's challenged, you said my kid saw this, there's no damages. The book is been removed, and I think that's gonna happen in most of the circumstances that we're talking about, so I don't know how applicable that becomes moving forward, but understand the conversation.
And that might be part of the balancing act, with this policy, to Senator Crago's exact point, is that helps to mitigate damages, as opposed if you were to specify that there's a minimum amount of damages, for example, then you would then we would have to address that issue when it is remedied. Do they still have to pay the minimum damage amount if they went and mitigated their circumstances by removing the book? So I do think we would have to walk through that carefully, but I personally think just having damages as an award, I don't think that's consistent with generally most lawsuits. Representative Chesick?
Thank you, Mr. Chairman. Co-Chairman Washut, I was attempting to get exactly your point in my amendment number 3, which failed for lack of a second. If somebody would like to revisit that and second that, we can have that conversation in the context of some actual language, which I think does resolve the problem that you're identifying.
Representative Brady.
Thank you, Chairman. I hope this is appropriate time. When we're talking about materials left out and then given so much time to get it reshelved, once a child sees something, she cannot unsee it. So, the damage is done. So I just want to be sure that they're compensated in some way.
And remind me, committee, we did have an amendment at some point in time that changed this language to actual damages. Did that? We didn't change that. It's just damages. Okay. All right. Okay. Any other amendments to page 5? Amendments to page 6?
And Mr. Chairman, just
Mr.
here,
Fuller, yes.
And my apologies when Senator Cole made this motion. I assume that the amendment to delete subsection C on page 5 would equally apply to page 6 as well for the school district.
I think that's right.
As needed, yes.
Yep.
Mr. Chairman.
That is correct. Any other amendments to page 6? Yep. You want to go back to 5? Let's go back to 5.
I'd like to propose page 5 between 26 and 27. Excuse me, 21, 27. The wording to amend it to 5,000 with litigation costs to be awarded to the winner, something to that effect.
Okay, is there a second? Okay, so you're talking about the language that says a court may award reasonable attorney's fees, And you want to insert language to the prevailing party? That's what, is that correct? Okay.
Yeah, Mr. Chairman, if I may.
Go ahead, Mr. Fuller.
And Representative Brady, please correct me. I think the intent of her amendment would be to require damages, and Representative Brady, I would leave it to you if it should be of $5,000 or not less than $5,000, and then the court must award attorney fees and costs if a person prevails in a lawsuit.
Chairman, thank you. Not less than 5,000 would be acceptable. Sorry, plus attorney fees and all costs incurred.
Okay, that was seconded? No? Is there a second? It was seconded by Representative Lean.
Restate the amendment.
The amendment is to add language to subsection D, the bottom half of the paragraph, to specify that the minimum award of attorney's fees and costs shall be $5,000.
And Mr. Chairman, I took that as damages. And then the damages awarded if you prevail would be not less than 5,000.
Oh, damages.
Plus the attorney fees
So
and
we're in the-
costs.
okay.
Unless I misheard Representative Brady.
I'm sorry, I thought she said attorney's fees.
Yes, I'm with Mr. Fuller, that not less than 5,000 plus all the costs incurred,
Plus,
attorney's
Yep.
fees, et cetera.
so you want,
Question?
are you just talking about a 5,000 minimum for damages, or are you talking about for damages, costs, and attorney's fees collectively?
Any damages, costs, and attorney fees collected.
Senator
A
Craig?
minimum of 5,000.
Okay, Senator Craig?
Yeah, so I was just gonna chime in. I think what the good representative's trying to get to, Mr. Chairman, is award damages. On line 23, you would say award damages of not less than $5,000. And then I believe the second part of her amendment is to make attorney's fees mandatory, not discretionary. We had that discussion earlier, but I think that's where she's going with that. I
Yes,
could be
two
wrong.
parts, yeah.
Okay, so attorney's fees shall be awarded to the prevailing party. Attorney's fees and costs shall be awarded to the prevailing party. And damages shall be set at a minimum of $5,000. Mr. Fuller?
And then, Mr. Chairman, my only question there would be, are the damages still discretionary or are they mandatory?
Chairman, Mr. Fuller, discretionary.
Discretionary, okay. All right. Discussion on this amendment. Representative Filer.
Thanks, Mr. Chairman. Maybe some of my free legal advice if I can get some. Is there any other statutes or anything like that that says for a civil lawsuit where there's a minimum amount that you're going to be rewarded if you win anywhere?
Mr.
Statute?
Fuller?
Mr. Chairman, I would have to do some digging. I'm not sure if there is a floor. I do know numerous statutes set a maximum. There may be in the consumer protection, I know because there's under federal law, there may be provision of triple damages that are available. I'd have to look in those statutes and see if those are applicable under state law as well.
Yeah, I don't know. Representative Filer?
Yeah, with that, Mr. Chairman, I wonder if this amendment would actually tie the hands of the court and the attorneys when you're proving this. So now you're tying the hands of the actual court, the judge, jury, whatever it might be, on a specific minimum dollar amount, period. So I don't know. I just don't see how a civil suit could ever have an actual minimum number or a guaranteed paid attorney fees. It's usually always been up to the discretion of the courts. This would be, I think, the only statute that I would know of that would ever be allowed to do
I don't know about the
this.
second part of your statement. I think, Mr. Fuller, are there any statutes that mandate attorney's fees in Wyoming?
Mr. Chairman, I think there are. I'm searching through right now, but it looks like I'm just seeing a couple statutes that say shall award attorney fees.
I think that one's a little more common, yeah. But the first part, yeah, I would agree with you. I can't think of any area of law that has a minimum award in a civil case like that. Representative Cheswick?
So I have several problems with this. I'll be voting no on the amendment. But the biggest concern I have is I need to see the actual language that's going to be inserted here before I can even consider how to vote. I'm hearing a disconnect perhaps between the mover and the co-chairman. Co-chairman says that we're going to say award attorney's fees to the prevailing party. What if the school district prevails? What if the school board prevails? So the person bringing the lawsuit now has to pay attorney's fees for having filed suit. That's the prevailing party. And that's not, I don't think that's what you intend. That's what I would be okay with that. If you bring a lawsuit and you lose, you pay the school district attorneys, or you pay the library attorneys. I'm okay with that, but I don't think that's what you're intending. So we have to clarify that language. How is that going to be written? Prevailing party, or is it only if the plaintiff prevails? I'm also opposed to the amendment generally because it creates a bounty hunting situation. I am opposed to this absolutely.
Chairman?
Senator Kolb.
Yeah, thank you, Mr. Chairman. Just to be clear about this, will this cause of action be removed if they take away the book upon review, and there won't be a cause of action? Yeah, that's what it is, right? Okay,
right.
Thank you.
Any other discussion, Representative Brady?
No, I just wanted to ensure that it's directed only if the plaintiff prevails.
And
Fine.
Mr. Chairman, I think the bill's already drafted to contemplate that. This would be the language on page 5, right at the end of line 25 and then line 26. That's now been amended in light of an earlier amendment, but it would only be if the bringer of the lawsuit, that is the resident of the county or the school district, prevails, that they would be required, the court would be required to award those attorney fees and costs.
All right, are we, Representative Filer?
Yes, Mr. Chairman, it's more free legal advice. That did bring up something, Senator, I just brought up. It was, even if there was a challenge, and we passed that amendment, even if there was a challenge, and say the challenging party on that to remove a book, put it in a different section, say they lost, the challenger lost that. Then they would be allowed to file a civil suit. But I did hear the statement of, well, you can't unseen what you seen, right? So does this still allow it to leave it open, Mr. Chairman, to, even if it, whether it goes through the challenge process or not, are you still allowed to file a civil suit no matter what?
Senator Craigo?
Yeah, Mr. Chairman, I don't think so based on the amendment we passed just a little while ago, Representative Lean's amendment. I don't think so. Okay.
Yeah, and I think you'd still have to, in order to get the minimum of the 5,000, you'd have to prove up all of the elements of your lawsuit still. I think you still have to prove damages. I don't think this takes away the necessity to prove it. It's just if you prove less than $5,000 in damages, you get 5,000 is the way I see it. But you'd have to get all the way to the end of the lawsuit for that to happen. So if it were remedied, then the lawsuit it could be dismissed. Co-Chairman Washit?
So I'm conflicted on the amendment because it seems like, yeah, I'll just hold it. Thank you.
All right, ready to vote? All those in favor signify by saying aye. Any opposed? Oh.
I apologize, Mr. Chairman. Can we ask for clarity on the amendment, given all the discussion to where it ended up before we vote?
Mr. Fuller.
Yeah, Mr. Chairman, I think the way I take the amendment, page 5, line 23, after damages, insert of not less than $5,000. And then page 5, line 25, delete may, insert shall. And then, Mr. Chairman, it would be similar changes on subsection D on pages 6 and 7.
All right, everybody up to speed on what we're voting on? Okay, all those in favor of the amendment signify by saying aye.
Aye.
Any opposed? No. Well, I haven't ruled yet, but that amendment does fail. Now I'll take a division. Okay, division, all those in favor signify by raising your hand. 1, 2, 3, 4, 5. All those opposed, raise your hand. 1, 2, 3, 4, 5, 6. Senator Hicks, did you want to vote? Okay. And chair votes no, so that does fail. Any other amendments to page 5? Yes, Representative Kelly.
Thank you, Mr. Chairman. I'd like to bring back that same amendment minus the $5,000 minimum, that they shall award attorney fees instead of may.
Okay. Is there a second? All right, it has been seconded. Is there a discussion on this amendment? Okay, all those in favor signify by saying aye.
Aye.
All those opposed? No. All right, that amendment has been adopted. Are there additional amendments to page 5? All right, I think we thoroughly worked page 5. Page 6. Page 7. Page 8. And that's the end of the bill. Yes, Representative Chestick, if you have a global amendment, now would be a good time.
I have two amendments that are not so much global, but they apply in a couple different pages.
Okay.
My amendment number 1 and amendment number 2, they are inserting language on 2 different pages, one for public libraries and one for school libraries. I'll move amendment number 1 first on page 5. Here we go again on page 5. After line 27, insert a new subsection E. This section shall not apply to any materials primarily designed or used for age-appropriate sex education for children. And a similar amendment on page 7, line 2 for school libraries.
Okay, you've heard the motion. Is there a second? Is there a second? Is there a second? All right, that motion does fail for lack of a second. You have a second motion?
Second motion is amendment number 2. Also, again, inserting a new paragraph E on page 5 after line 27, and on page 7 after line 2. This section shall not apply to any materials primarily designed to provide information to children about puberty, precocious puberty, or changes to a child's body as a result of puberty.
You've heard the motion. Is there a second? Any second? Any second? All right, that motion has also failed for lack of a second. Are there any other motions to this bill, amendments to this bill, excuse me? Representative Lean?
Thank you, Mr. Chairman. On page 4, starting on the middle of line 1 with except and going through the end of line 3 and just striking that portion.
Okay, one more time, I just had to scroll to page 3.
I'm sorry, on page 4.
Page 4?
Line 1.
Line 1, okay.
Halfway through where it says except and then through the end of line 3.
Oh, okay. Is there a second? It's been seconded. Discussion on this amendment?
Mr. Chairman.
Yes, Representative Lean.
Thank you, Mr. Chairman. The reason I moved to strike this is that we don't give doctors or physicians or PAs the ability to examine people within the library. And it just doesn't make any sense where it's placed in the bill.
So I'm just a little confused. I'm just trying to read this entire section to understand. We're talking about the definition of sexually explicit material, and it says, which is any of the following. And then, so I'm not sure I'm connecting that the examination has to occur in a library. It's a depiction of an examination in material. Is that right? Am I wrong? Am I reading it? It's just any depiction of an examination or treatment by a person licensed to provide care or treatment in a book, we're saying is accepted from that definition. Okay, any discussion on this? Okay, all those in favor signify by saying aye. Aye. All those opposed, no? No. All right, that motion has failed. Additional motions to this bill. All right. That brings us to the conclusion of the bill. Yes, we're done with amendments. We'll take any discussion on the bill. Yes, Representative Webb.
Sorry, thank you, Mr. Chairman. I think since the depth of discussion that we've had, I would still like to renew the option to be able to take some public comment from, limited public comment from maybe those that are in attendance.
Okay, I do appreciate that, and I appreciate the thoughts of it. I've also, been approached by some members of the public who think the same, and I just want to reiterate that we had over 2 hours of public comment on this bill. In addition to the public comment, if your email looks anything like mine, you have hundreds and hundreds of emails adding to the public comment. So I really think public comment was sufficiently noticed and given on this bill, and we made it very clear at the last meeting when I presented the option to the committee. I specifically asked you if you wanted to hold the bill over and work it in a subsequent meeting and close public comment, and the will of the committee at the time was to do just that. So I feel like out of fairness of the will of the committee and the process, we will not take any public comment at this time.
Thank you for your consideration, Mr. Chairman.
Thank you.
Appreciate it.
Representative Filer?
Yeah, thanks, Mr. Chairman. Members of the committee, I think about where this started last year at the end of session. When we first got a bill and it, pretty much criminalized people down to where we didn't even know who we were going to put in jail for, explicit material in a library or a public library or anything like that. So, my libertarian side of me always says, no, keep government out of our lives, completely. I would love that, just to have that, but it's the reality of today. I think there's been a lot of work done to this. I want to thank especially Representative Lean, Representative Kelly, Representative Chestick, so many of you that, really looked at, how do we find something that is going to work for Wyoming, not take away people's rights. I gotten, I don't know how many, over 1,000 emails that say, don't ban books, right? We're not, this legislation no longer bans the book. All does it might move it to a different section of a library or something like that. And now it's going to give challenging processes that libraries can come up with where we can have more public input, tied more into our communities. And like I said, Mr. Chairman, I'm more of, live and let live, government stay out of our lives. But with the times that we have today, And it's, you know, it's hard to believe that we even have to talk about things like this anymore, that we do have to talk about it. I personally would never allow one of my children to read one of these books, you know, and that's my parental right. So I think as this bill moves, if the bill moves forward out of this committee, I think a lot of work has been done, a lot of input has been put in. And I think I'd like just to put to bed the whole notion of banning books. We're not banning books with this piece of legislation, Mr. Chairman. Thanks.
Senator Craigo?
Thank you, Mr. Chairman. So just want to chime in, and I really want to take us back to this discussion, you know, on page 2, lines 13 through 15, which was probably the most important amendment we've talked about today. There was an amendment brought regarding the language provides materials aimed toward persons younger than age 18, which essentially, by leaving that, and we left that language in, and by leaving that language in, there is no place in the library that those books can go. And so we are, just to be clear, we are essentially probably banning books, because there is nowhere in the library now that those books can go, because they are aimed towards kids, they're aimed towards people who are not adults, but we have told them to go to the adult section. But because of the way that's written, they're banned. There's nowhere in the library, and so immediately your librarians are gonna have to start cleaning those books out. And that will be part of their process. So I just want to point that out. I'm a no on the bill because of that. I don't like these books either. I would never let my children read them. But I can't vote for the bill as currently written. Thank you, Mr. Chairman.
Representative Brady?
Just, thank you, Chairman. Just making a comment on good senator's comments. Relocating a book, even if it's to the top shelf, is not banning a book. A parent can assist, come check out for their child, or even take the time to read it to their child. They have access. So it's not a ban at all.
Additional discussion on this bill. Representative Lean?
Thank you, Mr. Chairman. I just want to go back to how this legislation empowers parents by cataloging the books to be placed into the adult section, that they still have access to them. The books aren't banned because they're readily available, whether you pick them up on your Kindle or you pick them up on Amazon or you pick them up in the library. They're just being shelved in a different direction. By some of the amendments we've made today, we've allowed for local control, and that gives us the power to give the state directive to give power to the local libraries so that they can put together a challenge process or a review process that works best for their local community. And we're empowering parents to know what's within these books and having good neighbors be able to say, hey, I read this book and this came out of it, and start that review process. And with that, I'm in favor of this legislation.
Senator Kolb?
Yeah, thank you, Mr. Chairman. So, yeah, this bill has come a long way, and yeah, there is a flaw in it. But I'm of the mind that there's a problem, and I'll just tell you, I think it comes from the American Library Association, and it all boils down from there and comes into the state of Wyoming through a different culture. And there's a huge problem, and to say there's not is not being honest. So this goes a ways to correct this issue. Now, is there some fault in it? There is, but I'll support this bill to get it out of here, because we can work on this as it goes through the process of the House and Senate. This problem is not going to go away. It exists. It's going to continue to exist until we deal with it. And unfortunately, it's in our lap, and as elected legislators, it's our responsibility to look into this, and I think we have. And like I say, the bill is 1,000% better than it started off. Is it perfect? No. But we have to do something, and I'm tired of waiting and kicking the football down, kicking the ball, throwing the ball down the road, and hopefully it'll get repaired. This is going to do more than we currently have, and I am in favor of it, not because it's perfect, but because it's important. Thank you, Mr. Chairman.
Representative Kelly and then Representative Chesty.
Thank you, Mr. Chairman. This is quantum leap from what we started when we were talking about criminal charges against librarians. I'm glad that's gone. I was dead set against that. I don't like any legislation that comes across as punitive, where librarians are considered guilty until proven innocent. That's why it was important to have this review process here. Now, as somebody who's infamous for having a libertarian streak, I'm against government telling individuals and parents what they have to do, but that's not what this is doing. This is government giving direction to government, that you will listen to parents and you'll set up some type of recourse for them when they're having an issue with how their taxpayer dollars are being spent. But at the same time, it leaves a lot of latitude for each district to come up with their own policies that fit their community the best. And then by changing it, so it has to be somebody who lives within that library district, again, community standards are held to that community. And the state is not giving one uniform standard to all the districts. So I support this.
Representative Cheswick?
Thank you, Mr. Chairman. So when we started on this bill in Casper, our meeting in August, I asked a lot of questions to a lot of witnesses that kind of pointed out some of the flaws that I saw in the bill. Some of those flaws I thought were correctable by amendments, so I proposed a bunch of amendments to it. They were all failed today, although some of the things I was talking about got worked into other parts, but most of what I was proposing failed. But there were also some parts of the bill that couldn't be corrected by amendment. I didn't propose amendments, and one of them is parental control. People are saying that this creates parental control. No, it doesn't. It takes away parental control. That's what it's doing. It's letting some parents say, I don't want my kids to see this material, so your kids can't see it either. You're going to take these books out of the library. Yes, you will, absolutely will. If you create a bounty system where you can go file lawsuits and get attorney's fees and get all the damages, you're creating a bounty reward system for people to file lawsuits against libraries. What about school libraries? This is a straight up ban. So the school library doesn't have the option of relocating, reshelving a book in an adult section. There is no adult section in the school library. So in the situation of a school library, this is straight up book banning, no question about it, not even debatable. I was particularly disappointed to see my two amendments fail, my first two amendments on sex education materials and materials to help children go through puberty. Those are things that are good. We should allow, every child needs good sex education. Where's that going to happen? It's allowed to happen in schools with parental consent. That's okay. I have no problem with that. But what materials are the schools now allowed to have to give good sex education to their students? Sex education materials, by their definition, are sexually explicit. They're all going to fail this test. So they can't have sex education materials in the library to teach their students. What about homeschools who don't go to school libraries? You can't find that material in the general public library either, because that amendment failed, and age-appropriate sex education materials are now banned. It creates liability to the school district or the public school to have that information. Good sex education would help reduce teen pregnancies and help reduce, therefore, the demand for abortions. It also helps reduce the risk of child abuse. Those materials are essential. They should be allowed. They should be available. And this body wouldn't even second the amendment to allow those materials to escape potential liability. Everything about this bill at this point is a problem for me. It deprives parents the right to control what their children see. If the book's not there, the children can't find it. It's not going to be available to them. This goes against parental rights, and I strongly oppose this bill.
Representative Bratton.
Thank you, Mr. Chairman. There seems to be some disagreement about whether or not relocating the books to the adult section is allowable, disagreement amongst the lawyers. So I do want to get to the bottom of this as this bill goes forward, if it does go forward, and I will be in favor of it. Public money should not be spent on Penthouse Forum and graphic novels depicting oral sex. But to me, there is a line, and we need to figure out where that line is. I was a high school biology teacher, so I do appreciate Representative Chestic's comments about sex ed and health information, but I do not believe that violates A through E on page 3. So I will be supporting this bill, and maybe we just need to make sure that prurient interest addresses those issues as far as sex ed and health information. Thank you.
Representative Brady.
Thank you, Chairman. A couple points as well, that sex ed should not be obscene as our bill is proposed. And I will vote for the bill. Another point is the books in the adult section does not create liability for the library. They're not banned, they're just reshelved. And again, that removes the liability from the library. In fact, it empowers the parents when the people know there will be mature content in the book by where it is shelved. So there is parental control right there.
Representative Kelly.
Thank you, Mr. Chairman. I have to be really clear about something here. The inflammatory language that there's banning books here, it's absolutely absurd to say that we're talking about having adult materials being in the adult section that adults can go get for their kids still if they want to. It's just not on the shelf, so my son goes in there and stumbles across it. Now, as far as the school libraries go, I taught sex ed in middle school. I didn't have to go into the school library to get the materials. We have textbooks. There's nothing in here that talks about school curriculum or the learning materials that you could bring into the classroom. It's just about what's sitting out on the shelves for the kids to wander in there and look at. And first of all, I concur. I've never seen sexual ed material for teens that was as descriptive as what we've seen in this bill. But again, I will reiterate the point that yes, they can teach sex ed, because again, curriculum and textbooks are not touched in this at all.
Representative Webb.
Thank you, Mr. Chairman. I'd just like to echo Representative Kelly's comments. This is not book banning. The intent is to keep sexually explicit material out of the hands of minors, and it does not infringe upon parental rights. If Johnny's parents wants Johnny to see the material, Johnny's parents can go and get it. But if Billy's parents doesn't want Billy to see it, then that parent still has that right. I can't see where it infringes upon any rights. Thank you. I will be voting for the bill.
Representative Chestic.
Thank you, and I will be brief in my closing remarks here. I just want to remind the committee that the definition of sexually explicit material does not include anything about prurient interest, or does not include any of the Miller test. This is way above and beyond the Miller test. The Miller test would allow sex education materials because it has educational value. This doesn't. This bans a lot more than what the Miller test would ban, and therefore I'm still strongly opposed to the bill.
Representative Filer.
Yes, thanks, Mr. Chairman, and I thought I was done. I really did. But I think, there's there's obviously some more questions and concerns about it. There's no doubt. But from what we started with last year at the end of the year to where we're at now, and we've made this kind of progress, there's obviously more work we can do if it gets out of this committee, gets introduced on the floor. You got 60 to 90 other people looking at this piece of legislation to perfect it. So if there's anything else, I don't see anything now that hinders it from moving forward, because a lot of the concerns I had are now gone. And I think one of them is Representative Lean's amendment. It's one of the best. It made me just feel a lot more warm and fuzzy inside about it. So with that, Mr. Chairman, I understand what Senator Craigo was saying about that children's section, that definition. So maybe that's something we need to work with LSO staff as it moves forward to make sure that we are not banning books in any way, shape, or form. We're just making sure they're in the right section of a library. And I also want to concur with the statements about parental control. I'm really big with parental control. And, if you want to allow your child to read a book like that, you're more than welcome to. There's nothing that says you can't. Just now, you're not going to be criminally prosecuted for it. That's how far we've come. And, so I think there's been a lot of work all the way around, and we can make this bill even better with these other concerns if it does move forward out of this committee. Thanks, Mr. Chairman, and I am done for now.
I just want to say, I agree with a lot of what has been said, actually on both sides of the issue today. I think it's really important what Representative Filer just said about the bill coming a long way, because a lot of the constituent contact that I've had, a lot of those issues, if not all of them, frankly, have been addressed by the amendments here today. And I think that important bills that address very important topics and complex topics like this rarely make it through the legislative process unamended. Because as we move through the process, we're going to continue to work this bill and continue to make this bill work for the people of Wyoming. So what we have today is probably not the final product, and I can appreciate that. But what I appreciate even more is that the reality is the issue that we're trying to address is a big issue, and it's a real issue. I've seen these books in my libraries, and I frankly believe that a lot of these books are nothing different than pornographic material themselves. My kids will never see these books. My family will have nothing to do with these books. If you move them, if we do nothing, we allow these books to continue to sit in the children's section of our libraries. And I frankly can't understand why there's any opposition to that, why there's any opposition to moving pornographic materials out of the children's section of our libraries and putting them in adult sections. And I agree wholeheartedly. I think Representative Webb has said it best, which is that if a child's parents want that child to see those books, they are in the adult section and the parent can go and get them. There is no loss in parental rights with this bill. There is only parental empowerment and protection of our children in our communities in Wyoming. And again, I'll reiterate that I don't think this bill is perfect, and I think we will continue to work it throughout the session, but I would hate to see this committee, after a long interim of addressing such an important topic, drop it here today and leave it unsolved. That, to me, would be a disaster. So I will be voting to move this bill forward, and I will be working throughout the session to make this bill even better for our children. Thank you. Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Committee, I just want to say thank you. Committee's worked hard. This process is about compromise. I don't think anybody got 100% of what they wanted out of this bill. I've gotten emails saying that we didn't do near enough. I've gotten emails saying you've done way, way, way too much. So thank you to the committee, because compromise is what we do. We work through these challenges. We look at individual words and definitions and try to get this stuff right. And to echo my co-chairman, I'm old enough to remember the day when adults would throw you out of the office if you suggested putting, this type of material in a school library. And today we have adults fighting to keep this type of material in a school library. So the world has changed. I don't think the bill is perfect, but we often say we don't want the perfect to be the enemy of the good. I think it's a good bill. It can still be worked further to address the good senator from Johnson County's concerns. I want to make sure we get that right. We can continue working the bill. I look forward to seeing an engrossed version of this bill at introduction. Because I don't know about the rest of you, but after we do a whole bunch of amendments, I have a pretty good idea of what we're voting on today, but I would really like to see the engrossed version. And then the rest of the body, whichever whether it goes to the Senate or the House, the rest of the body will also get a chance to see the work of this committee over the interim. and decide whether they want to introduce that bill. My biggest concern with this bill is that the biggest enemy in the legislature is time. We all know that. We're coming up on a 23-day session with the budget and recalibration, and we're going to have our hands full. But this is a very important topic, and I'm going to vote for it today.
Senator Craigo.
Thank you,
You were
Mr.
named in those last comments, so I
Yeah,
thought I'd let you
thank
respond.
Yeah, thank you, Mr. Chairman. I'll be brief. Most of us agree that the materials we're talking about should not be in the children's section. I have no problem with the school portion of it. My problem is that we're all talking about giving parental control and saying you can go to the adult section. The way the bill's drafted, and I just want to be clear in my closing comments, there is not an adult section left in the library. The way the language is written, children's section means the entire library. So there is not a place you could put the books we're talking about. And so that's my major concern. So as this bill moves forward, I think that's something the committee and the rest of the legislature will get to talk about. Thank you, Mr. Chairman.
All right, let's vote. It'll be a roll call vote.
Mr. Chairman, this is a roll call vote for 26 LSO 80, sexually explicit materials in libraries requirements as amended. Senator Craigo?
No.
Senator Crum?
Excused.
Senator Hicks?
Aye.
Senator Kolb?
Aye.
Representative Brady?
Aye.
Representative Bratton?
Aye.
Representative Chustic?
No.
Representative Filer?
Aye.
Representative Kelly?
Aye.
Representative Lean?
Aye.
Representative Singh?
Aye.
Representative Webb?
Aye.
Co-Chairman Washit?
Aye.
Chairman Olson?
Aye.
Mr. Chairman, we have 11 ayes, 2 noes, 1 excused.
All right. That bill will move forward, and we'll decide whether it starts in the House or the Senate. We'll make that choice later on when Co-Chairman Washington and I meet to discuss where all the bills will start. With that, let's move into our next topic of retail theft issues. We're only about 30 minutes behind, which isn't bad, honestly, given the depth of the last topic that we were on. We have legislation on this topic, 26 LSO 0082 version 6. Has this changed from our last meeting?
So Mr. Chairman, this version has changed, and I would point the committee to page 2, line 1. The first change here was to change the word absconds to travels. So that was the very first word in that paragraph, Romanet 1. Mr. Chairman, the other change was to say that you can travel not just from one county to another county in Wyoming, but from one county in Wyoming to another jurisdiction outside of Wyoming. So Mr. Chairman, those were the 2 changes the committee adopted in August.
Great. Committee, are there any questions on the changes? All right. Then let's roll into our testimony. We have first the Wyoming County and Prosecuting Attorneys Association. Who do we have representing that association?
Mr. Chairman, they were going to join us online. They're not online just yet, but I've reached out to them to let them know.
They're in court prosecuting. All right, so we can circle back to them. Let's go to Mr. Thompson, the Executive Director for our Wyoming Association of Sheriffs and Chiefs of Police. Welcome, Mr. Thompson.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, Wyoming Association of Sheriffs and Chiefs of Police. Our membership hasn't given me a lot of input on this concept, but what they have given is, based, I guess, on some of the comments we heard in the meeting last go around, was making sure that the crime the punishment fits the crime. So as this is written, it appears that any low-level misdemeanor would rise to a felony level. I've looked at it several times and don't have any specific suggestions other than maybe looking at the penalty section itself at the very end on page 4, where it says absconding for criminal purposes is a felony punishable by imprisonment for not more than 5 years, a fine of not more than $5,000 or both. And maybe adding something in there to limit the prosecution of that felony if the conviction for the criminal charges or the height of the criminal charges met a certain threshold, like a property crime over $1,000 or a violent crime, misdemeanor or felony, or whatever policy this committee would think about on that. But I do think that there is an interest in this law fairly applying to the criminal case at hand. And Mr. Chairman, I would like to also add that I was discussing, as you go across state lines, it's very uncommon for Wyoming law enforcement to enter a misdemeanor warrant into NCIC. And there's a lot of costs associated with bringing people back from outside the boundaries of the state of Wyoming. But there are also some misdemeanor cases that would surely rise to the level, misdemeanor domestic violence cases, violent crime against another person, or maybe you're early on in the investigation and the only evidence you have at that time is the misdemeanor portion of it, but there is the ability for it to rise to a felony level if investigated properly, or if we found the evidence that we might find being concealed in another county or another state. So in those aspects, we do think that there's important concepts in this bill, but we would support any movement to make it commensurate to the crime at hand. And that, Mr. Chairman, I'd be happy to answer any questions.
Any questions for Mr. Thompson? Yes, Representative Kelly.
Thank you, Mr. Chairman. Just for clarification, then we're talking about absconding for criminal purposes is a felony. So if the criminal purpose was shoplifting a six-pack of beer going across a county line, we've now turned shoplifting into a felony. That's your concern?
Mr. Thompson?
Yeah, Mr. Chairman, I do think that that's accurate in the way I read this statute, that could be, this felony provision could be applied to that six-pack of beer theft.
Any follow-up? No? Okay. Any other questions for Mr. Thompson? All right. Thank you, Mr. Thompson.
Thank you, Mr. Chairman.
Looks like we do have a prosecutor online. We'll now go to them.
We
Ms.
do,
Callis?
Mr. Chairman. She'll be joining us shortly.
Okay.
Yeah, and Mr. Chairman, we're just waiting for Ms. Callis to accept that.
Okay, Ms. Callis, we're just waiting on you to accept the invitation.
My apologies. Can you see me now?
Welcome. Yes, thank you. Please introduce yourself and then let us know what you want us to hear.
Thank you. My apologies for the difficulties. I'm actually at Reality Town at Evanston High School today, so I appreciate your patience in relation to this. I am Loretta Howison-Callis. I'm the Uinta County and prosecuting attorney.
All right, well, welcome to the Judiciary Committee. Do you have any comments specifically to this bill draft?
Yes, I wanted to note for you, as the president of the Wyoming County and Prosecuting Attorneys Association, we have voted and provided for our consent unanimously to support this bill, and in relation to its application would ask for you to have a do pass vote on this legislation.
All right. Thank you.
I'm certainly happy to answer any questions that you may have.
Absolutely. Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. I don't know if you heard our testimony just a moment ago from the Wyoming Chiefs and Sheriffs Association, and the concern was someone steals a six-pack of beer in one county, travels across county lines to the next county. Now we've turned potentially that misdemeanor shoplifting into a felony crime. you have any suggestions for us on how we might capture, because this was all began with a discussion of organized retail theft, and how we might narrow this so that we capture those criminals who travel from jurisdiction to jurisdiction, shoplifting just below the felony threshold amounts. That's part of the objective here. But avoiding the six-pack of beer scenario, right? Where's the sweet spot in your estimation of how we might do that? Could we say if it involves a conspiracy or a theft over a certain dollar threshold that's less than a felony? Any suggestions for us?
Mr. Chair, Representative Washut, there are two ways that we can address that I think can alleviate or mitigate your concerns related to those issues. I would not suggest putting in a conspiracy. A conspiracy would have a whole separate legal provision. However, there are two things that you can consider. One is that the way this bill is drafted, this is a specific intent crime. And so it would require us to demonstrate the person's intention in relation to the purpose of their crime. In addition to that, to mitigate the concerns that you have related to criminalizing misdemeanor offenses into a felony offense would be to do a grading on the statute. You can find those in the inchoate offenses in 6.1, I believe it's 203. Somewhere in that area is where they have the grading for conspiracies and solicitation. And so in relation to that, then you could ensure that a misdemeanor offense such as stealing a pack of beer does not become a felony by the transport.
Thank you.
Yes, Representative Chestik.
Thank you, Mr. Chairman. My concern is on page 3, line 15, the end of the line, the word "or." So the A, B, C, D are not elements, they're options. And the specific intent comes in B, I get that, but should we make, I'm concerned about the word "or." What is your response to that?
Ms. Callis?
I would argue that sorry, Mr. Chairman, I would argue, Senator, that the basic principle in relation to the transport, the initiating language at the start of the statute actually discusses why you are moving the product from one location to another. And so in relation to that, I believe a defense attorney is always going to say that this is drafted as a specific intent crime. Otherwise, we would have issues related to constitutional matters because there has to be an intention to commit a crime. Otherwise, we would be infringing people's constitutional right to travel.
Other questions? Representative Lean?
Thank you, Mr. Chairman. Thank you for appearing with us today. On page 3, there's a staff comment about absconding not later than X time after a crime or offense. Do you have any thoughts about a time period that may be valuable for a prosecuting attorney?
Ms. Callis?
Mr. Chair, Representative Lean, generally, I think that the intention of this crime is to facilitate, as you guys have discussed, the retail thefts that we're having where we have a Walmart or other small business that is got a system where they're in and then transferring it to another location to sell or distribute the property. I would say that I would discourage putting a timeline on that simply because there are going to be times when somebody stores or otherwise holds that material in order to provide a time frame for it to no longer be essentially at issue or concern for the individuals. And so I do not believe a time frame is necessary, but certainly would be happy to work with the association if that is something you want to include.
Other questions for Ms. Callis? Yes, Co-Chairman Washut.
Thank you, Mr. Co-Chairman. One more question. The page 3, line 12 through 15, we talk about disposing or concealing of the proceeds, property, or other items of value obtained. but we don't include evidence, other evidence of the crime. Would you see that as a beneficial add to that section, to include evidence of the crime as opposed to just the proceeds?
Ms. Callis?
Mr. Chairman, Representative Co-Chairman Wash, yes, speaking with the association and in our, of this legislation, we feel that this is a valuable tool that we're placing in our toolbox. It is likely to have associated other charges with it whenever we do charge that, but certainly as encompassing as possible in order to evidence the nature of these organized crimes and their transport of issues would be helpful to the prosecutors across the state of Wyoming.
All right, thank you, Ms. Callis. We appreciate you joining us and all of your insight that you've given us for this legislation. And it is, I will particularly note that it is helpful that your association took a vote on the bill and you're letting us know the position on the bill. I do, when we're dealing with an obviously criminal matter, I'll just say it is very helpful to have your association vote on the matter. And that's not always been the case from your association, so I really appreciate it.
Thank you, Chairman Olson, and it is our goal to try to find unified positions for our legislation as we go forward this year. So I appreciate the opportunity to testify today.
Great. All right. Well,
and if you guys, thank you.
Yep, you seem like a busy woman, so we'll let you get back to it.
Thank you so much.
All right. Is there any general public comment in the room on this legislation? Mr. Currenti.
Thank you, Mr. Chairman. Joey Correnti, resident of Carbon County. I like the word travel now being in here under the definition. It was a good call by whoever made that. On page 3, the staff comment for a request on possibly identifying a timeline, just as a comparison to other statutes, under the furtherance of criminal gang activity, there is a 3-year consideration, so up to 3 years after the incident. I think that might be appropriate anytime in the next 3 years. If they want to just hide out in the county for 3 years, thank good on them. If not, it gives them time as they're continuing further criminal activities, if they come back through the county or caught somewhere else in Wyoming within that 36-month period, to also have that additional absconding added to whatever they may be facing. And with that, Mr. Chairman, I will stand for any questions.
Any questions for Mr. Currenti? All right, thank you. Any other public testimony in the room? If not, we'll move to the virtual world. It looks like we have some public comment.
Yes, Mr. Chairman, we have Valerie Hoffmeister online.
Welcome.
Hello. I'm a bit nervous, and talking about this subject is always emotional for my family. I happened to stumble across that I had reached out and sent emails several months ago. So members of the Judicial Committee, I'm going to read so I can stay on task and not waste your time. Thank you for the opportunity to provide testimony on this critical issue. I just was able to read the bill, so I don't know the nuts and bolts of it, but I had reached out quite a while ago because my children have an abuser that escaped from the Cheyenne, for lack of better words, VOA. I can't remember the name of it exactly. And so I'm going to read.
Ma'am?
Yes.
I think you might be on a different piece of legislation. We are on the retail theft issue of absconding for criminal purposes.
Okay, so for retail theft.
Yeah.
Okay, so
I think you want to testify, potentially, you're looking under our 9th topic of the day, which is our grooming laws, grooming for children and offenses.
No, I thought the absconding was for for criminal, not for retail. I did not read that it was for retail, but I
Oh,
guess
yeah.
how I have you all there, I would love for somebody to reach out to me to develop a bill for the automatic prosecution of people for absconding. I emailed you all. So I misread that when I volunteered to testify. I did not understand it was for the purpose it was for.
But it's a separate issue. It's not retail theft.
Yeah, I think just in hearing what you've told me and in discussing this with my co-chairman, I think that your topic is absolutely relevant to absconsion, but it sounds like it's not limited to retail theft.
No, sir. It's violent crimes. It's criminal violent crimes against a person. This criminal, Clint Copenhaver, was not criminally prosecuted, and now he's eligible for stuff that he wouldn't. And I'm trying to work with the district attorney's office in Cheyenne to get him criminally prosecuted, but there is a very much needed legislature law for criminals with crimes against people, absconding, getting.
Okay, I think what we'll do is we'll have our staff provide you with our email addresses from the committee.
I've already emailed all
Oh,
of
you
you.
already emailed us?
Yes.
Perfect. Well, then it's
Yes.
out there and it's in our world, and if it's a topic of interest for a representative or senator, I would really encourage someone to take that up if you're so inclined. Representative Lean?
Thank you, Mr. Chairman. Might we ask Mr. Fuller, given the way that this is drafted, would this also apply to her situation because it ends up in the criminal code?
Mr. Fuller?
Mr. Chairman, without hearing all of this, I'm not familiar with all of the details. What I would note, Mr. Chairman, the bill draft is not limited to just theft. It contemplates absconding from one county to another or one county to another jurisdiction after the commission of any criminal offense under Title VI, the Criminal Code, or the Controlled Substances Act.
Okay, obviously, when we brought this, our intent was to focus on retail theft, but we've written the bill broader than that.
Yeah, Mr. Chairman, that's correct, and that was the direction, I believe, from the co-chairman at the first meeting.
Okay. Well, I guess we can go ahead and hear what you have to say, ma'am, about your situation.
I will further on, and if we need to create a separate bill, I am passionate about this, and as a mother protecting adult children, something has to be done to protect the victims. Thank you for the opportunity to provide testimony on this critical issue. My name's Valerie Hoffmeister, and I'm writing as both a Wyoming resident and the mother of a victim of a violent offender's escape. I urge you to consider legislation that would require automatic criminal prosecution and mandatory follow-through for escape from official detention by any individual incarcerated for a violent felony, with no discretionary declination to prosecute by the district attorneys. In my family's case, a man who was incarcerated for felony aggravated assault escaped from official detention. Following his escape, he returned to Gillette, Wyoming, where he began stalking my daughter and family, putting our safety and peace of mind at serious risk. While Wyoming law, statute 65206, already classifies escape under these circumstances as felony by punishable up to 10 years, there is currently no statutory requirement that the county or district attorney prosecute the escape or follow through to conviction. This gap allows serious escape cases to go unprosecuted depending on internal priorities, resources, or discretion. This is not just a matter of my family's trauma. It is a public safety issue. When violent offenders escape and are not fully prosecuted for it, 2 serious consequences follow. Victim safety is compromised, as which happened in the case with my family. Victims are forced to live in fear, knowing that someone dangerous has escaped with little to no accountability. In our case, Clint Copenhaver is allowed to ask for a community placement again in 2027 after escaping from one. And that's after U.S. Marshals were sent for him, and he was captured in Montana. After being here, he left and went to Montana. Interstate criminal records remain incomplete. If no conviction is obtained for the escape, the incident may not show up on national background checks. Outside of Wyoming, allowing offenders to move across state lines without their full criminal history being reflected. I'm asking you to sponsor, support legislation, or add it to this bill that you have that requires mandatory prosecution and follow through by district attorneys for escape by anyone incarcerated or detained for a violent felony, ensuring that charges are filed and not dismissed or dropped except under clearly defined exceptional circumstances. It obligates district attorneys by law to pursue these cases, removing discretionary declinations that too often result in no meaningful accountability. It ensures such convictions are entered into national criminal databases so other states are aware of the offender's history, and provides clear sentencing guidelines that reflect the severity of escaping from custody while serving time for violent offenses. This is not about removing prosecutorial discretion in all matters. It's about closing a dangerous gap that allows violent offenders to avoid accountability for one of the most serious breaches of public trust, escaping official detention. I strongly believe that by enacting such legislation, Wyoming can improve public safety, strengthen victims' rights, and ensure that violent offenders are fully held accountable for all of their crimes. Thank you for your time. Thank you for your service. That is genuinely thanked for. And please consider this important public safety issue. I'm available to provide additional details, personal testimony. I sent, emailed you guys, my son and my daughter are both victims of this man. And I emailed you their victim impact statements. I emailed you a letter that I wrote to the community programs asking them to please not accept them in their programs because we knew what would happen. And what did happen is he escaped and was here stalking. Other women are afraid to report Mr. Copenhaver's, and I take Mr. Copenhaver very lightly, crimes against them, as they are very afraid of this man. I'm working with Bill Edelman, but as of yet they decided not to charge him because he was already reincarcerated, but that allows for him to have privileges that he wouldn't normally have if he was charged criminally. Thank you for your time. Does anybody have any questions?
Yes, thank you, Ms. Hoffmeister. And I did go through and pull your email out of my inbox. I apologize for not seeing it earlier. We've received a lot of emails today.
I completely understand. I bet you guys receive thousands daily.
So I appreciate you sending those materials to us. Mr. Co-Chairman, go ahead.
Thank you, Mr. Co-Chairman. I did read your email, appreciate it. Representative Webb and I interacted on it, and I followed up with the director of the Department of Corrections. I think there are some legislative fixes that, mandating an elected prosecutor file a case is probably not going to be a feasible response, but I think something along the lines of requiring that an administrative conviction of escape done by the Department of Corrections have equal weight as a criminal conviction for escape when it comes to parole considerations, things like that. There's some things that can be done, and we'll take a look at it and see if we can find a sponsor to take that topic forward.
I would love that. Please provide them my email, and I will continue to reach out to members of this committee to see if somebody will kindly and respectfully help my family and the rest of Wyoming's public safety.
All right, any other questions? Yes, please, Representative Webb.
Thank you, Mr. Chairman. Mine's not so much a question, and I know time is of the essence right now, and this may not even be appropriate, but I know that Director Shannon is here, and he gave me a great, succinct description of this situation prior to our meeting this morning. And if you would like to hear from him, if that's appropriate, but that's totally your call. You're in charge of this meeting, so.
Thank you. Any other questions for Ms. Hoffmeister? All right, thank you, Ms. Hoffmeister, for joining us. We appreciate your willingness to share with us your comments.
Thank you.
Director Shannon, do you have some brief information that you can share with us?
Mr. Chairman, Co-Chairman, committee members, I'm Dan Shannon with the Department of Corrections. I have had quite a bit of interaction with Ms. Hoffmeister and regarding this, and I certainly understand her concerns. I'm not, Mr. Chairman, I'm not aware that this bill would address, they would almost have to, the individual after an escape from an ACC, this individual escaped from Cheyenne ACC, would have to commit a crime before they even did that if the initial crime wasn't charged with that of escape. This individual escaped, we issued a warrant, and we worked with our Cheyenne marshals to track this person down in Montana and go up and get him. If you recall, Mr. Chairman, approximately 2 years ago, the Parole Board presented before you and indicated that a person that escapes from an ACC, because they are community-based, they do not believe that that is an escape from official detention, thereby really, I think we need to look at our ACC laws to make that type of change. Anyone who escapes from an ACC, regardless if you're viewing it as a walkaway or not, we report it to our county prosecutors and ask for prosecution. At that point then, by the statute of the ACC statutes, we're limited to what we can do and they reapply. So I think that's the appropriate, and I'm willing to work with any legislators to address that matter.
All right, yeah, it does sound like it's a bit beyond the topic that we have and the ability that we have with the bill that we have, but it does sound like there might be some interest in working that. So I'm guessing the senators or representatives will reach out to you if they have any questions or need any help with anything. So appreciate you making yourself available.
Thank you, Mr. Chairman.
All right, thank you, Mr. Shannon. Any public comment in the room? Any public comment on, additional public comment online? Okay, we will close public comment. Committee, what is your pleasure? It's been moved and seconded. Are there any amendments to this bill? Yes, Representative Bratton.
Thank you, Mr. Chairman. So I have a question about how we amend the bill so the penalty matches the original offense, so that we don't charge the beer absconder with a felony. I'm not sure how to do that, but that would be a question I would like to ask Mr. Fuller.
Yeah, let's go to Mr. Fuller.
So, Mr. Chairman, I think the amendment would be to say absconding for criminal purposes shall have a penalty that's the same as the penalty as the most serious crime that is committed before the absconsion is completed.
That sounds like a motion.
I would like to make a motion to make that so.
Okay, we have a motion and a second on that. Discussion on this amendment? Discussion? Yes, Co-Chairman Washington.
Thank you, Mr. Co-Chairman. Unfortunately, that doesn't get us to the issue that we talked about in Casper, where was the individual organized retail theft group comes through town, steals right up to the threshold of the felony crime, and then goes to the next county, does it again, goes to another county, does it again, that sort of thing. You're only going to have misdemeanor crimes, and we heard testimony a moment ago that some jurisdictions won't extradite on these misdemeanor crimes. So I think the intent, at least my hope, was that we would find something below that felony threshold that would allow it to be a felony crime, maybe not a six-pack of beer, right? But when we're dealing with this type of organized theft or that's part of what we're getting at. It's how do we deal with these guys who steal right up to the felony threshold, then travel to the next county and do it again. And then neither county will extradite them because they're only charged with misdemeanors. So that's my worry about your amendment. I think it still leaves a gap that is being exploited by these organized retail theft groups.
Senator Grego?
Thank you, Mr. Chairman, and I don't know the answer, but if we're looking at the subparts, and staff has a good comment on requiring intent on subparagraph A, right? So subparagraph B and C, in theory, there's a different element required there, and if we were to change and add intent on paragraph A, we get closer to being in line. I mean, we're talking about the situation when we brought this up at the last meeting, literally steal a six-pack of beer, drive across the county line, that's a felony. We don't think that should be a felony. If you steal a six-pack of beer, drive across the line with the intent to continue the criminal operation and steal another six-pack of beer, that changes the calculus, right? And that's what I think the co-chairman's trying to get to. I don't know. I mean, it's a complicated thing to get down on paper and to get right, because we do not, I mean, I think I speak for all of us when we say we don't want to make it a felony to steal a six-pack of beer in Sheridan and drive to my town in Buffalo to drink it, and that's a felony. That's not the intent. But if you're driving down there, and we get these all the time, we just had some of these earlier this year in our county. Literally, they were committing misdemeanors on purpose, county to county, and that happened to be credit card fraud, but it was the same thought, right? It wasn't necessarily shoplifting or retail theft, but the same thing could apply. So I don't know the answer, Mr. Chairman, but I see exactly what the co-chairman's getting at, and I agree with him, so.
Okay. Senator Kolb?
Yeah, thank you, Mr. Chairman. But you have to approve this element in a court of law, right? You have to be able to show this conduct and prove to a jury or judge, I guess, depends on the situation, but a jury, that they're guilty of such conduct that you're committing an organized, in a situation where you've done it multiple times in for purposes of what we're trying to address here. Or, I mean, I thought we were protected because you had to prove the element in a court of law in front of a jury. And so you couldn't just propose it if you wanted to. It has to be proven that this is organized crime in this particular case that we're trying to get down to? No?
No, it's not. It's not for organized crime. So if it were even, you don't have to prove that they orchestrated an organized event of going from county to county to county. You're proving for the criminal purpose of absconding, you're basically proving that they went across state lines.
Well, do we want to?
Or county lines.
All right, well, that's the issue at hand then. So then do we want to add language, or can we add language to repair it? Or is it not repairable to amend?
Senator Grego?
Mr. Chairman, so I think it's possible. I'm just not sure. One option would be to get rid of either
get rid of subparagraph A, right? So just the act of driving across the state line with or county line, excuse me, county or state line with no intent to commit a further crime would not, we could get rid of that. So that wouldn't qualify as absconding. Or you could put it down as, change it to what staff recommended, which is with the intent to elude law enforcement, because as currently written, A does not require any specific intent. Paragraph B and C do. They require specific intent. The intent either to commit an additional criminal offense or to dispose of or conceal the proceeds. Right, so those are both specific intent. You have to, there's a furtherance of an additional act on B and C, but A, it's just the act of driving, literally, or traveling. I mean, it could be on a bike, or we could do it by horse, which could happen in my part of the world. So, yeah, I think that would be an option, is you could get rid of A or amend it. I don't know if amending it completely solves the problem, but it makes me feel better that they were doing it with the intent to elude law enforcement.
So let's take it step by step. So first, we need to decide on this amendment that we have in front of us. We have some other options to address the co-chairman's concerns, but right now we need to decide whether we want the penalty for committing the act of going across the lines, county lines, to be equal to the misdemeanor that they already committed, or do we want to elevate it to a felony when they cross lines? That's the substantive question in front of us right now. And then I think we need to look at some of these other remedies that might address the actual heart of Representative Washat's concerns. So discussion on the amendment, Representative Washat?
In the interest of time, maybe voting for the amendment's the right thing to do, and then we can try and work on a more robust solution for this session. If we move the bill forward with the penalty only being a match to the underlying crime, and then we can take it up in session and see if we can massage the language more thoroughly, or we can continue to work the language today if time allows.
I mean, I really think the staff comment on intent is pretty significant. I think if you had to prove intent, yeah, I just think that moves us more in line with what we're trying to do. If it's gonna stay as a felony, if it's a misdemeanor, I don't really care that much about intent, but. Co-Chairman Washat?
So I guess all the different starred lines and staff comments, I'm not quite sure, what is the actual A and what is the staff comment recommended A that we're dealing with here? It looks like after having committed any criminal offense under this title or the Wyoming Controlled Substances Act, that's A on line 22 through 24. And then we have another A on line 35. I'm assuming that's the recommended staff comment language. And so if we replace 22 through 24 with the language on 35 through line 2 on page 3 of the staff comment, I think that moves us a long way.
I think so.
All right.
Might be a better.
Back on the original amendment.
Yeah, might be a solution to I think you do one or the other. You either adopt this amendment and make it so if it's a misdemeanor, it's a misdemeanor when you abscond, or you reject this amendment, we keep the felony provision, but we add intent. Does that sound like a clear policy choice for everyone? Okay, all those in favor signify by saying aye. Aye. All those opposed?
No. No.
All right. All those in favor, go ahead and raise your hand. 1, 2, 3, 4, 5, 6, 7. All right, all those opposed. 1, 2, 3, 4. Okay, I do think that amendment passes. So I think that eliminates that staff comment. There are some other staff comments. Yes, Representative Cheswick.
Thank you, Mr. Chairman. I don't think it actually does eliminate the staff comment. I would move the staff comment in addition to what we just did to add the intent element, so replacing A from the staff comment for what's there now.
Okay, is there a second? Second? Is there a second? All right. Yes, Representative Singh?
I'm sorry, there's a little confusion here. Would you mind, the bringer of this amendment, can we just hear that again?
Do you hear the motion again? The motion is the staff comment on page 2.
Okay, thank you.
Okay. Anything else with this bill? All right. Sounds like it moves us along a little bit, but maybe we still have some more work to do. So let's go ahead and take a vote on this bill.
Mr. Chairman, this is a roll call vote for 26 LSO 82, absconding for criminal purposes, criminal offense as amended. Senator Crago?
Aye.
Senator Crum?
Excused.
Senator Hicks?
Excused.
Senator Kolb?
Aye.
Representative Brady?
Aye.
Representative Bratton?
Aye.
Representative Chestick?
No.
Representative Filer?
Aye.
Representative Kelly?
Aye.
Representative Lean?
Aye.
Representative Singh?
Aye.
Representative Webb?
Aye.
Co-Chairman Washit?
Aye.
Chairman Olson?
Aye. And Mr. Fuller, is it a majority of the Senate or the majority of the Senate present? What is the rule?
Yep, Mr. Chairman, it is a majority of them then present, but Mr. Chairman, there were 3 ayes for the Senate.
Right, I just wanted to double check. Okay. All right. It's lunchtime. You know, we have an aggressive afternoon, although I will say, we do have some ability to shave some time off on one of our topics, which will be the one that we get to right after lunch with Mr. Detai and the working group. But I don't know, unless you commit a mutiny right now, I would still propose that we come back at the 1:30 time. It would give you an hour for lunch, hour and 3 minutes. And we'll be on topic and maybe get out of here at a decent time. So with that, all right, not strong enough. With that, we'll be back at 1:30.